have Mr. Pradosh Kumar Mohapatra. Sir, can you hear me?
Yeah, yes, very well.
Yes, yes. All right. Okay. Just give me a minute. I think there is a constant message thing. That's okay. All right. Mr. Mahapatra has 37 years of experience in the banking sector, and we said that this is the pendency of cases and its socio-economic and legal implications. He is here specifically for the economic part. He is with over 2 years of stint as the head of NBFC, and he's the former GM of the Federal Bank as well. Mr. Mohapatra will be addressing us on the economic aspects, the banking aspects, and we look forward to hear from you, sir. And you can obviously make remarks about whatever speech has been made so far as well. It's a pleasure to have you on board.
Yeah. Esteemed dignitaries in this forum and all dear participants, I wish you a very good morning and a day full of good deliberations. I take this opportunity also to thank young Nisank, the founder of Gambit Enclave, Howrah Chamber of Commerce and Industry, Mr. Santosh Upadhyay, his family, having organized such a wonderful program, a very relevant topic which has affected and continue to affect lives of millions of people in our country today. The socio-economic implications of legal cases. So, such a wonderful topic when Nisang told me and Mr. Santosh Upadhyay told me, though I was not feeling very well, I couldn't resist the temptation of joining and giving my few of my thoughts, sharing in this platform, so that in the process I come to know many things. The last 1 hour we have heard Mr. Malhotra speaking about so many informations which were not known to me particularly. I mean, we read here and there, but he encapsulated it so nicely. So I will just say a few of my sharing of my experience in my 40 years of professional career in the banking and the non-banking financial sector. I am the witness to the implications of legal cases largely affecting the financial sector. So while talking about this particular subject, first of all, I'll give you very alarming piece of information about the pending cases, the amount involved. It is very scary. As on 22 March, the total gross NPA of the bank's non-performing assets, as all you know, the bad loans of the bank is more than 10 lakh crores. And this is only a NPA, which is not performing. Then many of them are getting entangled in court cases. While in bank, we had the age-old option of filing a money suit from in the year 1993. The government found that the courts are getting choked with various money suit, and the banks are really struggling to get back their money. So they had the first idea of setting up some DRTs, debt recovery tribunals, exclusively for the banks and financial institutions, as we all know. And it was started off well. The idea was great, but what happened? In the process, 39 DRTs are set up in the country. There are about 5 DRATs, the appellate tribunals also are there. But I think the system has nearly faced a collapse in the last few years. To such an extent, the high courts had to intervene. The Supreme Court also had to intervene. They said the High Court can hear the DRT cases because they know that there are no presiding officers. The infrastructure is terrible. The number of cases in various DRTs more than 1 lakh, and the total amount which are blocked in various DRTs was to the tune of 15 lakh crores. Please imagine 15 lakh crore of public money is getting entangled in court cases. If it is recycled, it is coming back to the bank. Who are the beneficiaries? It is the public. Because the bank gets the opportunity to invest it into fresh loans, the eligible borrowers, and the economy of the country as a whole gets the benefit out of it. Banks are the lifeline of country's economy. They are the backbone. They are the medium through which the money goes and it comes back. But somewhere there is a bottleneck, there is a clogging is done. What will happen? It is like you don't have a case to do a bypass surgery. You can only overhaul the system of the legal system, or what is affecting this money, what is affecting this functioning of this DRTs and DRATs only has to be addressed. Then, not to stop with that, the government of India, they found that there are so many functional and financial aspects getting affected in the process. So DRT is not the answer. So in the year 2000, in the year 2016, the Insolvency and Bankruptcy Code (IBC) was enacted. A combination of company law and various other recovery mechanism was brought in one place so that the bank get a lifeline once again. But there also the kind of traffic we find in NCLTs was so tremendous, so much disturbing that they had no other option during the COVID. They raised that limit from 1 lakh to 1 crore just to reduce the burden on NCLTs, because it was not shared only by the banks, but also by various other people from the commercial side. So what are the options left? The civil courts, the civil cases. I think the number which Malhotra sir gave is will also contain part of this bank-related cases, among other cases, and this DRT, this number which I gave you, where we are heading for. And if we talk about the socio-economic impact, and if it is not felt and understood by the government, then what can be said? As far as I know, I have attended the DRT cases in my entire career many times. The presiding officers are often taken from the banking sector. They are, people at a very senior level from commercial banks with a legal background. They are appointed as presiding officers. What stops the government to find out, identify more such people and fill up the vacancies? Why there is no the required intention or the kind of willingness on the part of the government to identify this problem? We have several meetings with the commercial banks heads by the Ministry of Finance. They talk about how to contain NPA, but the root cause, how to address, to have a well-oiled judiciary system, which is so easily available to the banks. If we don't rectify it, then what is the point in just discussing that the problem is increasing, the amount is blocked, and the money flow is choked? Then again, from the government side, also from the taxpayers' money, some capitalization is done to the banks. So why there is no need of all that? So in nutshell, what I have to say, we have all the avenues open in front of us to make it better, to set it all right. But I think a forum like this, which I believe is carrying the message from here to the ministry, if it is heard properly, we can certainly be the voice of the people to make it reach the ministry and if something can be done, there is overall improvement in the system, and the benefit is passed on to everybody. The benefit to the borrowers for a quick disposal of the cases, the benefit to the financial institutions to get back their money at the earliest, which has a strong impact on availability of working funds, on the pricing of the loans. Again, the pricing of the loan, the benefit is passed on to the borrower, because if the banks are not capable to manage their funds effectively, it will have an impact on the pricing. And if that benefit is passed on to the borrower, it is going to do good to the entire society. So from the bank's perspective, a lot of things I can say, but in nutshell, this is what I have to say. We were about to hear Dr. Nirmal Kanti, who is also having a lot of information. Let us reach out to him and say what he wants to say. In between, I will also give you some more
insights.
information.
Yeah, absolutely. No, without a doubt. Okay, it's okay. And thank you so much, sir, for joining, because I know all the health problems that you've been battling recently, and despite that, you coming here and addressing us means a lot to me. And I see there is a constant, technical glitch on the part of the speakers and the panelists. And sir, B.B. Mishra, sir, if you have any questions, you can ask, or we'll be proceeding to the key speaker for the session today.
Thank you. Mr. Mohapatra is a class fellow of mine, and I take the liberty of calling him by his first name. I say, Pradosh, we can bank with you. Thank you, no questions.
Thank you so much.
Can I come in? Yeah,
absolutely, sir.
I think Mr. Mohapatra raised a very valid point with regard to the functioning of the tribunal. And I think it has become concern for all of us. The tribunals are created, but in spite of that, the filling of the post takes too long a time. Now, I remember there was an exercise undertaken by the government where out of 31 tribunals, they were merged and they were converted into 17 tribunals. Now, once the tribunals are clubbed, the very objective of having a specialized tribunal to deal with a particular subject gets defeated if you merge many subjects in that. That is what has happened. I remember the SAFEMA tribunal has been given responsibility of 4 different tribunals under money laundering also, under other acts also. And neither the presiding officer nor the members are in position for the last more than 1 year. If that kind of situation, and when the selection is made by the committee, which is generally headed by a Supreme Court judge, it takes months together to get approval from the government. So I think this is not a healthy situation. The objective of defeating the tribunal for quick justice delivery in these specialized matters get defeated in case the appointments are not made and the infrastructure is not provided. I remember way back in 1997, 9 judges bench in L. Chandra Kumar case has said that all these tribunals should particularly be put under one ministry, namely the Ministry of Law and Justice. But unfortunately, that has not happened in spite of the fact that these observations have been repeated a number of times, even in Madras Bar Association case also in 2005 on tribunalization of justice. A 5 judges bench again reiterated these observations, and later also it has been made. But unfortunately, the tribunal's appointments are getting delayed, cases are getting pending there. And if after constitution of the tribunal, if you have to go back to the High Court, then what is the fun of having such tribunal? Better put the jurisdiction back to the court so that the cases are taken up in the normal courts instead of getting delayed in the tribunal itself. The better course will be the government should be sensitized about filling up these vacancies quickly and providing proper infrastructure so that they can function properly and pendency in the courts can be reduced. I just wanted to make that observation. Thank you very much.
No, absolutely on point. I'll just unmute you, sir, just a second. Yes, Mohapatra, sir.
I'd like to add a point here. I have seen some bank officers, very senior bank officers with a legal background. They discharge the duties of a presiding officer so nicely, so effectively. There are instances in Kolkata DRT itself. In a particular day, it was a record for the national record, 240 cases were disposed of in a single day. So it is possible, but from all corners, the required support by way of infrastructure is not happening. If so many vacancies are there across the country, what is stopping the government from identifying more people from the banks who are easily available? They are only willing to join the post of a presiding officer, not a very difficult job. Having worked in a legal department of a bank, they can easily discharge the duties so effectively. And also the number of lok adalats, if that is defined that in a month there has to be compulsorily a lok adalat in across the country, it can also dispose of many cases. Unfortunately, it is not happening. When it happens, it gives fantastic result.
I entirely agree with your observations. I mean, there is no way I can say that I don't agree. I entirely agree with your observations.
Thank you, sir.
Right.
But answer is not with me. Answer is with the government.
Yes, sir.
Yes, no, absolutely. And thank you for your observations as well.
Hello.
And I thank you, sir, so much, Mohapatra, sir. I know that you've been constantly, not great with the health, and I pointed out early as well. Now, PK Malhotra, sir, raised a lot of points about the judges as well, and who better to address it than the former Honorable Justice of Calcutta High Court, Mr. Shivakant. And I just wanted to say that, even though put out the motto that justice delayed is justice denied, it also must be understood that justice hurried is justice buried. And I will put out his brief bio in the chat. You can read it. He is our key speaker for the day. And obviously, you guys, all the speakers can, when they feel they can raise their hands and ask questions. Over to you, Mr. Shivakant. Thank you so much for joining us today.
Hello, everybody. I'm happy to be here amongst you. Your motto, which you have said, and the point being raised that delay deny the justice. There is a denial of justice if there is a delay in disposal of the case. Everybody is interested in disposal of the case in God's speed. This term, which we have inculcated, was spoken by the Prime Minister of British Prime Minister Gladstone had in his speech. He has spoken about that delayed justice delayed is justice denied. The host has rightly said that justice hurried is justice buried also. It's true. We all have introspection within ourselves that how India is lagging behind. It's not so. Our Indian judiciary is far, far above all the world. They may be having artificial intelligence, but we have got manpower. And the mindset we do have. All the judges in India, they are working 24 hours. I have lost my life. I had wedded my life with the judiciary since 1987, 88. When I started as an advocate in the original side in Calcutta High Court, I was there in 1985. I was enrolled and I did my practice for 2 years. I was doing job as a retainer for the junior retainer for the Punjab National Bank in those times. My senior solicitor, who was in Eastern India, Punjab National Bank, he was the sole retainer. I had to undertake job. 4 or 5 cases I had to conduct and get it disposed of Calcutta High Court original side in suit matters, banking suit matters. and they were being done. Sometimes why there was a delay? Delay was because of the officials who were not reporting with the files. In the arbitration also, I had seen, I was working in the arbitration court also. Lot of cases used to be filed under section 41 of the Arbitration Act 1940 in those times. So there were set parameters. If you want interim order, there were provisions provided under section 41 that why you should get the interim order. Provision was provided very clearly that have you determined the agreement, arbitral agreement? Have you referred the arbitration agreement to the arbitrator? Whether the reference was made. Thirdly, the reference whether has been made upon by the arbitrator named. Then whether the arbitration proceeding is pending. All these sine qua nons were to be shown to the court. Only then you could get the order of interim injunction. Now, section 9 is there in the current Arbitration Act. What do you get? When you are apprehending, you can go. Even if there is no agreement, you can go there. You can try your luck. You can gamble in the court or in the corridor of the judiciary. These are not the questions which are to be solved. Why you make the legislation unnecessarily? Repeal and legislate. You are legislating, you are enacting laws. What for? For the welfare of the people. Less is fair. Then where is the infrastructure? Who is to do it? You have not constructed your house and you have purchased the sofa and all furnitures. They will be all on the street. So these are the things which are plaguing. The court is worried about, no doubt about it. And this Lok Adalat we are talking about. Lok Adalat is the creation of Legal Services Authority Act 1987. 1987, the act was passed. Why it was not enacted? Why it was not given effect to in 1987? Why it came into force in the year 1995? What was that? It was Honorable Justice P.N. Bhagwati who forced the government to implement it, to do it. Then, and that's why on 9th November we celebrate Indian Legal Services Authority Day. What was that? It was all the group, the lawyers group, they were all objecting. When we started Lok Adalat, they were all objecting. You must have seen in my profile that I had innovated. I was the chairman of the Legal Services Committee appointed by the State Legal Services Authority here in Calcutta by the Calcutta High Court. Justice Samresh Banerjee was the first chairman in Calcutta High Court, perhaps, to my knowledge. So he held one journal meet. From my district, I was there. I was there in Purulia district then. I joined and he was talking what he was showing, displaying things that National Legal Services Authority has given all these guidelines that you can innovate theories, how to formulate. You just have your own mindset that how you can get the cases disposed of. I worked as a munsif, as a judicial magistrate also, as SDGM also, as Metropolitan Magistrate. I was Assistant District Session Judge, then Additional District Session Judge, District Judge, then came to Registry, and then High Court Elevation. So it's a long journey. When I was Munsif, I had seen lot of partition suits were pending. Grandfather will file the suit and the grandson will get the fruit. Why? Who is responsible for it? The person who filed the case, who conducted the case. We have filed the case with rupees 5. With rupees 5 only. 15 rupees is deficit. So what is the bench clerk writing? Routinely orders are being placed. I had to stand up in my courtroom to sign the record like this. When I was undergoing training, I asked my senior Munsif that brother, so Dada, why it is what you are signing without seeing the record? Like when you take the seat, you will also understand. These are all adjournments. You sign it. These are all adjourned according to the pleasure of the party. One party. Second party is deprived. Sometimes second party will according to his. Sometimes lawyer will come saying that, sir, you had given adjournment to plaintiff. So today I'm indisposed of, I'm otherwise not. I'm busy. As a matter of right, you grant him the adjournment. Adjournment is one of the cause, major cause. Yes, judges has to grant adjournment also. It's not possible for take up all the matters together. If I take up 10 cases listed in my board, the other 90 will be, when they will be placed? They will come in the next year. Framing of issues taking 4 months, 5 months fixation if you are taking time in the civil suit. Deficit court fees, deficit, DCF, it goes like this for 1-2 years. Who is responsible? It is the litigant who is responsible. You blame the court, always. It is only the court who is to be blamed. But blame the society at large also. They are also responsible. Society as a whole, public as a whole is defective, not the system. System is made defective. There will not be any delay. Deficit court fees, all right. Dismiss for default. Again, they will go for the restoration. I'm ready to pay. Second, when the stage comes for summon takes time. Thirdly, when the person is appearing, he will ask for the time. If there is an order of injunction, that has to be addressed first. If the interim order of injunction has been granted, it has to be contested, either varied, set aside, or modified. That will consume time. And summon stays also. There are so many cases where substituted service of summon is pending. You have to deal with them. I was impressed with the article by Honorable the then Chief Justice of India, M.N. Venkatachalaya. It was appearing in the Statesman. I had gone through it, and then I was Munsif. So he had elaborated with regard to court management and the case management. Then case management, it clicked me. And what I did, that I clubbed. In one day, I clubbed all the applications which are pending for substituted service of summon. Next, all applications 10 to 15 like that, because unless the interlocutory applications are disposed of, you cannot come up in the P board. Then again, there will be a lot of cases, lot of suits which are to be pending for settling debts for peremptory hearing. Then the parties together, when they come, it is fixed. Again, one plaintiff will take time. Then defendant will take time. Plaintiff is examined partly, defendant will take time. Lawyers are so burdened that he is only piecemeal, he is taking up evidence. It is disgusting for the judicial officer and in the court they are working for. In the criminal sessions cases, if a judge is very strong and in a particular case and on merit, if he has passed an order of conviction, the groups are all scared that he is convicting-minded judge. They will manage whom? They will manage the sessions clerk. Who is the acquittal-minded? There he will garnish some cases. He will manage. These are also the problem there. Now we are talking about criminal case bail matters. Yes, the Honorable Supreme Court has given the verdict. Bail is a rule and rejection is an exception. But the rejection is an exception only in cases where the offense is non-bailable. In all bailable offenses, bail is the rule. In non-bailable offenses, bail is a discretion. For 37, for 36 is the bailable offenses. For 37, then for 38 only the district session judge or the high court can hear. Lot of cases you file here a sessions case or session judge also and the high court also. Sometimes there is separation that whether there is any other case pending in the higher forum or not. There are a lot of technicalities in the law itself. Law is not simple. And the jurists, they have got their own mind to interpret it also. It's not so easy. Here in India particularly, bail granting, it cannot be liberal all time. 436 I am hearing about. 436A, fine. It's a beautiful, what is called provision given. It is also a method of reducing the pendency by releasing him bail, but not by that there is no reduction of the case. Case remains pending. Granting a bail is not the disposal of the case. Honorable Supreme Court in 3/4 judgment has already said, in all appeal cases, they should be allowed to remain on bail. 389 is there for the session judge who grants bail only for confirmation by the, subject to confirmation by the High Court. Before the High Court, when the appeal is preferred, we allow him to continue if he is on the bail. But if he is not on bail, the bail is to be considered for his release. Why? Because if I cannot hear out, but when there is no scope for hearing the appeal instantly or in near future, only then. If I can hear the case today, why I will grant you bail? Everybody is interested in grant of bail. When the accused goes on bail, he like this. Ab khoste raho. What happens? On the next date place, he is not available. The lawyer is also not available. Lot of cases are pending, even in the High Court, criminal appeal matters. Because those accused persons who were granted bail, they have absconded. The duty of the court is to issue administrative notice to him. After the administrative notice, what is to be issued? Then warrant of arrest has to be issued. He is not available. Say, for example, the accused has died. No one has cared to report to the court that he has died. The case may be filed forever. Matter ends, matter is taken off from the board. They are not in the pending list. There are so many cases the judges they dispose of. They are not listed properly that they are disposed of. There may be fudging of the figures as well. We are talking about 5 crores pendency in the judiciary, lot of cases pending. When the lawyer comes, they say, where is the matter pending? When the accused is not available or accused is available, is in custody, we give the priority to the custodial accused. He needs to be heard first. Lawyer is not available. If you appoint the amicus curiae as per the verdict of the Honorable Supreme Court, he is not equipped. He needs the paper book. Then you have to prepare the paper book for 1 week time it will take. Then again, the lawyer will say that I am not equipped. I have 1 week time is required for my studies. Obviously, it's quite natural. Then the advocate on record will come. He will say that I was there, I missed the list. Then who will work? The amicus curiae or the advocate on record? You decide it. And then again you proceed and dispose of the cases. Person was 40 years in jail. He was merely enjoying the jail custody. He was not in jail custody. He was happily living there, if I say so. I was district session judge. I used to visit every month the jail. I have seen the plight there. Systems are all well in the place. In the ward, TV room, TV is also placed. 3-4 channels is also provided for their entertainment, music and all that in order to reform them. 498 accused persons are segregated and kept in a different ward. All reforms are there. There is a welfare scheme there also. I had held a legal awareness camp there also. Even I have always asked for, every district judge used to take note of and send it to the Honorable Court for information. In Bakuda district, I was acquitting one accused after his custody for about 5 years or like that. When I was acquitting, he could realize that I am acquitting him. He came on the dock and said that, sir, please allow me to remain. I have committed wrong, to remain in the jail. And outside, what I will do? He is doing gardening. He is getting 2-3 times meal. In every week, he is getting 2 days non-veg also, as per his choice. Why should come out? So have you thought of this? You talk about 20 years in jail. In Rajasthan High Court, 20 years in jail, 10 years in jail. Calcutta High Court, 40 years in jail. Was that decision disposed on the merit? Whether he was found guilty or not guilty? It was only on consideration that since long he is there. No one cared for to come before the court to say that yes, this person is languishing in jail for a longer period, incarceration since long. The Honorable Supreme Court decision was there. Like long incarceration in jail is not a ground for bail in a case. If you talk about the bail as a rule, then the murder accused should also get the bail. There was a decision of the Honorable Supreme Court on the subordinate judiciary and the magistrate that the judicial magistrate or the CGM, they should not venture in granting bail in cessus tribal cases. Whereas 437 proviso says about can venture in granting bail even in cases that is provided there, that is looked into. That is not there. Our litigants responsible for the delay and pendency. Lawyers group, they take time, adjournments. Not for their cause, obviously for the litigants, it's at the instance of the litigant. Isn't it? There are cases pending in the High Court also. DRT has to entertain, but overstepping that he comes to seek interim injunction. It is there. When I was Legal Services Authority, I had devoted my 2 hours after judicial court for the Legal Services Authority committee. And I conducted pre-litigation suit. Lot of banking cases, they had defaulted in filing the case, even not issuing the notice for revival of your debt. So they had no claim before the court because suit is barred by limitation. Even I am talking about the bankers. But then when I had held the legal awareness camp, they came to me, the bankers, bank managers came to me that these are the cases. We had the claim, but we cannot file suit because it is barred by limitation. Okay, that is true. I want to get the matter disposed of through Lok Adalat. And I got it done. I called that very borrower also. They simply you pay the principal amount. And they were happy with that. Lot of cases are there. For 36A, what is the proviso? They cannot be released on bail after completion of half of the period of sentence. If there is a default on the part of the accused in not allowing the conduct of the trial before the trial court. I passed such order in Rose Valley case. You will see proviso, continued detention, and reasons to be recorded. It's not so. It's not technically that yes, half of the period he has undergone, you just let him off. Let him merrily enjoy his life. This is not so. You will commit a heinous crime and you want to exercise your what is called liberty as enshrined under Article 21 of the Constitution of India. Fine. Honorable Supreme Court have passed the judgment. They are to be read in between lines and comma full stop. Then one has to understand in what perspective, marshalling of the facts, what was the conscience statement there. Imtiaz Ahmad case also, in the recent time, the Honorable Supreme Court passed the judgment with regard to the bill itself. Certain criteria have been given, guidelines have been given. It is all being followed. There was a decision by the Honorable Supreme Court for a committee to be had in the every High Court. I was one of the member of that committee. And that formula that you can say that All India Judges Association and others versus Union of India in 2003 case, the apex court had observed that the strength of the judges must be increased every year by 10 per million people for the next 5 years, so that the desired ratio of 50 per million people could be obtained, which was recommended in the by the Law Commission 120th report. That was there. Is that followed? We had calculated that in West Bengal we required 1,700 judicial officers. How many judicial officers are functioning? In Bankura, I was dealing with, I was in my own jurisdiction. One additional district judge, he was on leave. There was a trial of the Maoist groups. One day, they were being brought from central jail, Midnapur. They were there in, every day they were being produced. The presiding officer is not there. I was holding the charge simply. I should leave my own trial and then I entertain. Then what happened? The SP approached me, whether accused persons, they are not leaving the lockup. Then I had to go there in the lockup itself, near court lockup. I offered them a cup of tea, water. And they were saying that decide our fate. If we are wrong, put us behind the bar as a convict, so that I can get some privilege of a convict, and under trial has got a different privilege. Otherwise, why we are ferried like this? Every day we are brought here, there is no trial. I assured them that tomorrow I will take up all your cases. The witnesses, whoever are available, I will examine them. I had to do it. So you have to understand the inner things also, how a judge has to face. One night every day. If I have dictated my judgment, it takes nearly 2 hours to check it, recheck, and get retyped. Finally approved. On average 2 hours, even 4 hours like that. And vacation, the judges are on vacation. Everything, CAV matter is all there in the head. They are not happy. They are not clear in their mind. All points they are all talking about. Judging is not so easy. You place your case, that's all. But to judge, and you burden a court by placing all the judgments. Even the overruled judgments are being placed. If you don't quote them, you have to at least answer. They are not happy. That can be one of the grounds for the appeal also. These are not the situations which are plaguing the courts, what is called disposal. And you are asking for disposal. Disposal is not the decision. Quality and quantity cannot run together. We have much talked about this question. Justice denied. Where the justice is denied, who is responsible? We are all responsible in some way. It is better you go for Lok Adalat. Lot of cases are being disposed of by Lok Adalat. It is all win-win situation. In West Bengal also, you must have understood that when it was introduced, there were some hostile situation being created. When I held in my district for the first time the Lok Adalat, first Lok Adalat, 26 cases were placed and around 20 to 24 cases were disposed of. One newspaper wrote that a lot of cases pending, though Lok Adalat held, nothing was done, like that. It is a hostile reporting without understanding the data. One senior advocate told me one day, he was just whispering. In those times, there it was CPM ruled state. I'm going out of way. Pardon me for that. The one senior advocate said that Josh wrong bodle. I just heard it from my chamber. Then what I did, that I appointed him as a member of Lok Adalat, as a judge. Next month. Then when I was offering him the alliance and the certificate, then I asked him, Mr. So-and-so, which color you have decided today? Whether it was red, blue, or white. Then he started chuckling. Like, sir, amar kotha sune niyechen? Yes, I had heard it. I overheard. What is this? You were judge. Can you understand that which color you have decided? What was the class of people and litigants for whom you favored, or whom you have not favored? This is not so. Chair is like that. There may be layman perception in differently. Lok Adalat, alternative dispute resolution, is the solution. That is section 89 of the CP code. Section 89 CP code was introduced long back. Now after the amendment, why it came? Who was the class of people who were objecting? It was recommended long back. Then in our article 39A was introduced. Who asked? It is the Honorable Supreme Court. Verdict was given, then it was done. In our constitution, founder of the constitution had not thought of so many things. Like right to education and all that, they were introduced. Environment. These are all the articles provisions now they're in place. It is only because of the president judgment. It is only because of the judiciary. That's why I say that the Indian judiciary is most competent judiciary all over the world. How many cases they are disposing in a day for judges? We don't have the infrastructure. Even over 2-3 judicial officers, sometimes they had to use the others' privy, washroom and all that. They are not provided properly, their position. When I was a judicial magistrate, it was a small desk given, one anti-chair and that. Infrastructure, it is all problem. Dr. Rajendra Prasad also said, the first president of India, he had spoken about the pendency of the cases. He pointed out that the bar has to be strong. If the bar is strong, the judge is strong. If the judge is strong, court as a whole is strong, your judgment is strong. And what is the field for the appointment of the elevation of the High Court judges in majority? They are from the lawyers group, from the bar. So unless the bar is strong, the strong judges cannot be appointed. then some of the judges will give you some condition which you cannot fulfill. Like you go and tie the rakhi and all that. You will get such mindset. All right, I don't want to go further in all these situations. You just tribunals, central administrative tribunals, they are to be final. Central administrative tribunal, their order is appealable. Mandamus appeal before the Honorable High Court, before division bench. Lot of cases pending because you have given the avenue, that's why. Otherwise, that can be decided. In all states, why there should be? In all states, there should be the central administrative tribunal. That should be manned by chairman as well as the judicial member and others. There are a lot of vacancies there. The Honorable Supreme Court directed the central government thereafter, some of the tribunal members and the chairman, they were appointed. Why? There should not be willingness on the part of the state. All the time the court, you have to seek direction. So you are just using a platform, judiciary as a platform all the time. In a place where I was posted as a magistrate, a lady came before me and asked me straightway, why you have put my husband behind the bar? Jail warrant was issued. Why? Because he had not deposited 14,000 rupees as what is called arrear maintenance. It was. Then I asked that why you filed the case, maintenance case. Look, I never been that I will take money from my husband. I know my husband is unemployed. He cannot feed me. Then, because my law clerk in the village, he said that corpus, when the maintenance I will get you through court. She could follow that, yes, the court, perhaps court will provide me the maintenance. So it is the government which has to provide the maintenance. That's why she put her LTI in the petition under 125 CRPC. How many cases are pending there? There are up to numbers of cases, 125, wife and husband class. You see how many judgments are there, how many kinds of judgments are there, how many laws are framed. Domestic Violence Act, CRPC 125, if matrimonial suit 24, 26, 25, afterward, after the divorce, it goes on. So in between wife and husband, there are 4 or 5 cases pending. There is one case, 4 or 5 cases, offsuits are there. You clear them thereafter. This is not the kind of situation where there is a delay. How do you expect the speed? The God's speed, one can say. Only you think that, yes, the judge is the artificial intelligence. You must be aware of one judgment of Calcutta High Court, Chartered High Court, in 1916. It is reported judgment. There is one sentence judgment. You go through ILR, go through Privy Council judgment. They are very brief. Why our judgments are so lengthy? Because there are a lot of conflicts you have created. Population, then every group, to certify them, we have prepared law without providing infrastructure. POXO came being misused. 498 was introduced, it was misused. Police had the handle. He will arrest the person, the husband, only on the vacation time, like Saturday, so that he can keep him behind the bar in his custody for 1 day or more than that, and then so that he get the chance to place him before the magistrate. They were misused. Arnish Kumar has said that, right? Now it is also the duty of the magistrate to provide for the help there itself instantly. He has to prepare a list of the lawyers who will be attending there during the police file. If any accused is unrepresented by a lawyer, he will provide the assistance from there. So there is Legal Services Authority that is also providing all assistance. No doubt, a trial judge is a linchpin of a judicial system. He is the root. He all prepares the brief, and the paper book is prepared, for which the appeal courts they work. In civil cases, I have already talked about that presentation of the plaint, then how deficits, court fees, summons, it takes time. Then you are asking for written statement. Now the amendment after amendment, something has been streamlined. Even then, there are precedent laws by which they are taking shelter, and they are asking for the liberty to file. All right, you file it with cost and all that. Discovery and inspection of the documents, it takes time. Framing of issues thereafter. Then your settling dates of trial. Then peremptory hearing.
Right.
After further hearing, thereafter argument, then judgment. These are all the stages which are to be taken. It takes time.
Right.
And I had the experience that at the stage of argument, the plaintiff himself is coming with an amendment application.
Right.
I said that I am ready to pass judgment today itself after hearing the argument. No, this is my application. First, it has to be decided.
Okay.
If you reject and if you do something, they will go to the High Court.
Yes.
High Court will obviously entertain that you look into the matter first. What is the amendment? At the time of argument, after going through the record, he thought that no, there is no least chance of winning.
Right.
So lawyers should also not be having this mind to
process.
winning, that thinking of winning.
Yeah.
You have to cooperate. You have to assist the court. If you cannot assist the court, because you are the first person to know the things. The judges are made to know. Even the law is to be made to know to the judge. Even the King Council and the Queen Council, under whose care and supervision the law is enacted and framed. Even they don't know the law. They have to be made to know the law. Here is the law. This is what is the law which he speaks of. This is what is my right, under which I can get the relief. So, in the recent past, you will see that in the High Court, there are a lot of cases, PIL cases are there.
Right.
And then police inaction cases are there. Those cases can be dealt with by the magistrate. Still, it is for the lawyers who have created all these writ applications. In some matters, even the police is not in the knowledge. Otherwise, they would have dealt with the case. That is not there. So all stakeholders, they are required to cooperate to the judiciary. Only then. And there has to be a pendency. If you think of the court, you have to think of the pendency of the cases. Delay is different, pendency is different. Backlog, which we have faced in the recent past, it is obviously because of the pandemic situation. Our Honorable Chief Justice is also very much conscious about it. and has spoken about the infrastructure which is required to be.
Right.
The law ministry, cabinet law ministry has already had given us the, I was also in the administrative committee of the High Court, and for creation of the fast track court for the POCSO.
Right.
Per 100 cases pending, there has to be court, fast track court. Where is the creation? How many courts have been created? A district judge, when POCSO was what is called, it was enacted and then it was to be applied. Who was the forum? It was only the principal district judge. Now additional district judges, they have been vested with the power. Like you are talking about commercial courts. How many cases are being disposed of? In Alipur, how many sub-judges courts are there? Assistant district judges courts are there? 10 in numbers. They all are vested with the power. They used to be vested with the power of everything. Enormous power they had. Enormous jurisdiction they had so far as the pecuniary jurisdiction is concerned. Million cases they could conduct. Now only one High Court judge will do. One will do. Because according slot is given, financially.
Yeah.
Pecuniary jurisdiction has been made. So only one person, how many he can do? In a district, 10 judges, they are doing cases. If one case is disposed of by 10 judges in a day, 10 cases are disposed of. If in the district there is only one commercial court, the judge will dispose of one. You just see the ratio. So there was no question of doing this, just making this act unnecessarily.
Sir, sorry to interject. Since you've been talking on FTCs, there was a constant question about it also, and like it was addressed to both you and PK sir. Obviously, we'll go to BB sir also if he has any questions. And you're talking about FTCs in reference to the 2011 Finance Commission. Do you believe like the fast track courts have been a complete failure since the idea of their setup? Like, because I see you hinting at the quality of justice that the fast track courts have been delivering, and and also in the sense that not a lot of infrastructure has gone in the right direction when you talk about development of these fast track courts. So with that question, we like to proceed and conclude also. But since you're speaking on it, I had to interject, and this is from an audience member. Do you feel FTCs has failed?
FTC, it's not failing. Who says that it is failing? They are working. They are court as good as a sessions court. It's a you can say that it is a misnomer now. If you ask me to dispose of in a day 13 cases, sessions cases, it is possible. Can you hold the trial?
No.
No, it's not possible.
Right.
I've already pointed out with regard to nitty-gritty of the procedure.
Absolutely.
And where there lies the delay.
Delay
is being caused there. Lot of cases at the stage of the argument also the matter is being deferred. Somebody goes to the High Court and gets the stay. Stay order is also one of the reasons. In some cases are obviously delayed because of the stay order. I was there in the district judge in one district. When I was holding, my duty was first, when I assumed my court, my office, I used to hold in inspection of my office. I was visiting the record room. I could see that there were a lot of matrimonial suits pending. From the suit register itself, I could see. Then I asked the solicitor that why these are cases pending. Take me to the place where the cases are pending.
Yeah.
I could see that it is for 2007 it is pending. What are the cases? 13B cases are pending. Compromise, what is called divorce decree on consent. So 18 months is more than enough. After 18 months, it has become infructuous. Then I started giving notice to all the lawyers, advocate on record. They have said they have settled outside. So it was not your duty to have pointed out to the court that they have settled and it can be disposed of. So are you not in error? So there is a fault, which has caused this has resulted in pendency of the cases, and we are showing the result like that. There were a lot of singur cases, miscellaneous cases I had seen in my district. Then I asked why they are pending. They were pending in bulk because of the stay by the Honorable Supreme Court. In those time, I could not touch those records. Lot of cases were pending.
Right. Even Mr. Santosh has a question. You can just unmute yourself, and I think go ahead.
Myself.
No, you are unmuted, sir. You have to unmute yourself. You're not unmuted. Yeah, go on, please.
Good afternoon to everyone. Vibhu Mishra sir, Shivakant sir, PK Mohapatra sir, PK Malhotra sir, everyone on the panel. My question to all my panelists is that most traditional law colleges have woefully inadequate infrastructure, unprepared and uninformed faculty, and limited access to legal databases. Truthfully be told, very few of the supposedly elite institutions in India can boast of those attributes. No, actually my sadness and anger towards the traditional law college stems principally from the remarkably poor quality of the students who study in these institutions. So my question is that whether the quality of lawyers is affecting this pendency of case. They are not being able to draft the properly. There are lot of laws.
Absolutely.
Colleges.
I think it's gone across.
Yeah.
Yeah, anyone can take that. Even if PK Malhotra sir is on the dais, he can also proceed. You unmuted now. You unmuted. You'll have to unmute. Yeah.
Okay, now it is okay.
Yeah.
So anyone can take this question.
Yeah. So we'll
actually it's not so.
Okay.
Now the class of lawyers, the young lawyers, they are very smart and they are very well read. They are well equipped. They are well equipped with the artificial.
I'm telling that is quality of education. The quality of law colleges is a problem or not? After getting LLB degrees, all lawyers are in equal footage. All are privileged. And all are
you must take some experience from your senior, you know. और गुरु का जो है ये है ना, उसका जरूरी मंत्र जरूरी है.
Guru mantra. Right. I think PK Malhotra sir
because going through the books, law books are not like a novel worth reading. It is an application. And you can apply only when you have got some experience, only then, not otherwise.
You can put down your hand now, Papa. You can just.
Yes.
Sir, even you are working as the director, I guess. And also, before that, I'll address the speech. I think all the points were pretty well made in terms of, you've highlighted even the colonial aspects of how it still implicates in not only in the court of law, but also in our constitution. And whether it is just a court of law or a court of justice is also a matter that needs to be discussed and deliberated upon, because both are different aspects. But the question that Dad raised, I think it's a valid question in terms of, the legal education, because ultimately you are helping in culminating of judicial and legal officers. Proper training needs to be imparted. What do you have to say about that, PK Malhotra sir? And also, before I go to you, big shout out to Vibhu Mishra sir for keeping his video on throughout. Sir, if you have any questions, you can go on and ask. No issues about that. Yes, sir.
Yes, thank you. I do have two questions and two observations.
Okay.
These are addressed to our Justice Prasad Sahab. Sir, I'm indeed grateful to you for with your experience of lower judiciary, you could very precisely pinpoint where the delay takes place, and some of it that can be avoided, some of it that cannot be avoided. So he said one has to live with a bit of pendency. It is part of the justice system. So that's very well taken, sir. One question is, as a officer, I have seen quite often my trials have got delayed when the High Court calls for the lower court records and just keeps them somewhere. They want to stall the trial, so they will not do anything with the LCR, call LCR, and then the LCR reaches the High Court and it remains there.
Yes,
God
yes.
knows for what length of time.
Mhm.
Isn't that a source of delay and an unnecessary delay? Number one, sir. And the other question is from your observation about non-GR cases. Sir, should we not have more and more law allowing compounding instead of taking it to the judiciary? Let it be compounded not by the courts but by the executive. So that will reduce the pendency on the courts. Non-GR cases, for example, why take it there?
It is there in the Police Act itself. Those they have the provision. They can.
Some of
they
it
have to
has
place
become, sir, some of it has become compoundable.
Yes, yes. All are compoundable. It's not so that they are non-NGR means petty cases. Petty
Sir,
cases are compounding just upon paying nominal fees.
then
What is called fine.
why take it to the judiciary, adding to their burden?
That is there. So you have the second class magistrate appointed who will deal with all these.
Why should it go to him, sir, at all? If you have 5 crore cases, might as well do without a few hundred.
No, then you have to. There are cases which are decided by the police at their own end. Simply pay the fine there, and the matter gets disposed of. And what they are saying, they are giving the challan, you to pay the fine. You have not paid the fine within such and such time. Only then they are referring the matter to the magistrate. Not otherwise. So there are so many cases like that. There are a lot of violation. We Act violations are also there, and they are right in their own proceeding that they have to do under the law. Then they are booking the person. He will not respond to that, and sometimes Lok Adalat is also being held. There should be Lok Adalat every day, and every court should have the Lok Adalat. And I used to do it when I was in Jalpaiguri. There was a direction given by the Legal Services Authority in those times. I don't know whether they are all in place or not, but I was cited for that. I used to take up in my own courtroom in the down what is called stairs. I used to take in the desk, bench clerk desk, and then the person. All those cases used to be referred by the magistrate, which were compounding cases, and even non-compounding cases where with the permission of the magistrate, it could be compounded. There is already list is there, schedule is there, the 20 section is there. That provision is already there. So we used to dispose of the lot of cases. We used to dispose of a lot of the cases, but only the presiding judge could be the additional district judge only. And there used to be one lawyer or a social worker was in the panel, and he used to sit with me. So that way I had disposed of a lot of cases. So and you just see that I was in the profile you must have seen with regard to pre-litigation partition suit. So why I had done this, because in my grandfather's time, what I had seen, what was my observation, that even today we don't have the partition amongst our own. My two grandfather and the what is called uncle, they are not having division, midst and bound. So we are happily in the house and the landed property, enjoying with the what is called mutual memo of partition.
Sure.
In village there used to be a mean. He used to prepare memo of partition, and that used to be considered. And in long time, in the Supreme Court used to consider it that memo of partition under Section 35 of Evidence Act, it used to be accepted. But now it cannot be, because as a what is called evidence of partition. Partition has to be by meets and bounds or by deed of partition. That is there. So because of this thing, it is very difficult. So when I thought that yes, even the court fees is not required, preliminary decree, if you are interested to get it, it will go on for years together. For preliminary decree, you can see and you see that 4 brothers, they can divide themselves, have memo of partition. I did it. And
Right.
actually, practically, I got it done in my when I was a chairman of a committee, and it was a test case, and I placed it before the Lok Adalat, and Lok Adalat passed it. So there was a seal given, and it was preliminary decree. So now, if you want to execute it, you have to put it before the municipal court, very court, and then put the execution case for final decree, the appointment of what is called commissioner and all that, partition commissioner, get your properties divided by
Right,
bits and
sir,
all
right.
that can be done. So
Right.
I have saved at least 4 years by that process. When I just gave a what is outlook. It was placed before the executive chairman, the then Somaresh Banerjee, I can remember, and he had circulated amongst all the district judges, and sent a letter
Right, right.
of appreciation also.
Right.
So
I think-
it had played magic, in Alipur court and many other district courts. Lot of cases were disposed of like that. And then what
Sure.
happened? What happened? Who is deprived? Because if I'm professional, then
Right.
in one court, when I was conducting trials, I was South Divisional Munsif there. So there was a directive given by the Honorable High Court that all the trial courts, in civil courts particularly, they should fix the PH and FH matters, and the adjournments, if they are giving, adjournments should be given by them in open court, because they are not known to the parties. That's why this was the given. And so I started maintaining that, complying with that direction.
Right, right.
So what happened, one lawyer, when I was alone, I was about to rise just for the recess. Then he said that I want to say something, sir. So yes, what you want to say? The only bench clerk was there and Adali was there. He said that you are being paid by the state exchequer. From where we get payment? We get payment from our client. So if I have got 100 cases, if I can get 100 adjournment, 50 adjournment at least, what I can get? We have some earning out of adjournments.
Right.
So you are disclosing everything.
No, I think you addressed this
well,
also.
I should not address this, but of the way I am addressing this, it is not soothing well. I am explaining it to you, but this is my experience. I said that I am complying the Honorable Court's higher direction.
Absolutely.
Many of the litigants, they don't get the date, and on the next date when fixed, then you are not coming with your witness.
Yes,
the witness was not in the knowledge of the date, and you have not given him because you are busy. So that there I cannot compromise.
No, well noted, sir. I think BB sir has another question.
No more of question. Two observations.
Yeah.
Thana Singh case said did not come from NCB. I was in NCB that time when it was coming in the Supreme Court.
Right. I'm not blaming NCB. I was in the High Court. I was the chairman of the Drug Disposal Committee.
Sure.
For a period, I made it 0. The pendency we a lot. What was the decision by the Honorable Supreme Court? Very, very bad observation with regard to the West Bengal performance. That there was no data even. You have seized and there is nothing of that sort. And that I undertook. Earlier, Justice Bakshi was there. The Bakshi, Honorable Justice Bakshi, and I was also there with him in the committee. And thereafter, I was chairman. So I undertook the job to get it 0. So
can I put forward my second observation?
At present, Mr. Administrator in that NCB, I think he is and now he has been ranked Director General Police. So you might be in the knowledge on IPS. So he did a tremendous job, and I'm thankful to him that he could pull up the area.
Right. Sir, I'm going to mute everyone on the panel just so you can put out your observations, and then we'll take the concluding comments from each of the panelists, including PK Malhotra, PK Mohapatra, and BB Mishra sir, and obviously Justice Shivakant Prasad Farmer. I'll just mute you once. Yes, sir. Go on, please.
Sir, it is about apportioning the blame for adjournment. Sir, I'm not able to agree with you that the litigant public is to be blamed. Sir, obviously they will have a share, but the lion's share of the blame will go to the court. Sir, no advocate can get an adjournment on his own unless the court agrees to it. He can only plead for a adjournment, but who ultimately allows the adjournment? It is the court. I have seen very sad cases where 50 adjournments have been taken without a single hearing. These are, of course, the PC Act cases. I'm talking of Dhanbad, not very far from Purulia where you worked. And I'm sure the work culture will be not very different. Number of cases were there in Dhanbad where more than 50 adjournments have been taken. And every time the court has allowed it. If the court manages its affairs more forcefully and says, fine, you take a adjournment, but at this cost. And if you're not ready next time, let it go for ex parte hearing. I don't think anybody will ask for adjournment.
Right,
That's my observation. I may be wrong, sir.
Right. And sir, anything else do you want to add? Because
no.
Okay. Sir, any concluding statements? Just 30 seconds about the summit or anything else you want to address any panelists? Because after that, we'll close and we'll go to each panelist individually. For that, B.B. Mishra, we can start with you, sir.
No, not exactly. One comment I'd like to have is, can we expand the offenses where compounding can be done? At the moment, let's say we have X number of offenses which can be compounded outside the court premises. Can we add it? Can we add to X plus 30? So 30 new offenses are brought in the compounding umbrella so that they need not come and clog the courts. That's one.
Right.
Second is that we cannot always say that Singapore is a different legal system. I'll move out.
This is in reference to PK Malhotra's point, right?
Sir.
Yes, sir. Go on.
We will talk about Malaysia, where the system is quite similar. They inherited from the British. It was British Penal Code, BPC, which was almost copied and made into Malaysian Penal Code. Incidentally, 302 is the section for murder even under the Malaysian Penal Code. They inherited their legal system. They got their independence 10 years after we got it. So they got 10 years less time than us. But still their murder cases are decided very fast. Their cases never remain pending for such a long time. I had a word with an advocate of Malaysian courts. Subsequently, he has become a minister. He's a man of Indian origin. So it is based on conversation with him. I'm telling this. It's not always the system, sir. The way we are operating that system, that probably is, there is something wrong here. These are two. Third question to Malhotra, sir. Sir, we amended the 1973 PC Act, CRPC. CRPC was given a total new look in the year 1973. After that, number of police officers have voiced that the conviction rate has gone down after the amendment of CRPC. Disposal rate by courts have fallen. And third, and the very important point, that police doesn't have the benefit of legal advice at the investigation stage. And these are the reasons for poor performance and pendency. 73 CRPC is completing 50 years. Isn't it a long time to give it a look? How has it fared in the last 50 years? Or is there a need to have a fresh look at it? These are the three. Thank you very much. I have nothing more to add.
Right. Thank you so much, sir. It's been great, and the sense of professionalism you've shown again by, keeping the video on. I myself had to turn it off for like 15-20 seconds. And we'll go to PK Malhotra, sir, because all the number of questions were directed to them. Then we'll go back to Mohapatra, sir, and finally Mr. Shivakant, and we'll conclude this session. I can see Upanyu, sir, also is there on the panel. Good to have you on board. And Mr. Sanjay also, thank thank you for being throughout. P.K. Malhotra sir, you can have the dais now.
Thank you, Nishank. I think we had a wonderful discussion, and most of the panelists have expressed their view one way or the other. But I think all of us are on board saying that pendency is a matter of concern. Now, question blaming either judiciary or litigant or lawyers, I think if we blame only one particular quarter, that will not be correct. It is a systemic failure which we are talking about. And in that systemic failure, what changes are needed to ensure that ultimately the man on the ground gets justice? If that is not getting, blaming one organ or the other is not going to serve the purpose. Judiciary is doing wonderfully well, no doubt about it, with all the constraint which is at. But to say that the judiciary alone is doing best and all other organs are not doing, will not be a correct statement. That's my submission for consideration of this House. You talked about the amendment, this compounding of offenses and power given to the executive officers. Let me tell you, in most of the commercial laws which have been recently enacted, and if there is a violation, the provision of settlement has already been made. Take, for example, with regard to the market violation, those who are dealing in the securities market, the Securities and Exchange Board of India has been specifically empowered to settle the matter out of court on payment of certain fine, even without admission of guilt. Similarly, under the criminal law also, under the Companies Act also, some of the offenses for which earlier there was imprisonment provided, they are being decriminalized to ensure that the burden on the court doesn't increase. You see, there has to be a shift on the policy of the government also. Instead of making every small procedural violation in commercial law as an offense to be tried by the court, I think there should be a procedure where the authorities created under the Act itself are in a position to settle those matters. So I think what we are looking for is, when we are making laws, we ensure that we are not making faulty laws. When it comes to seeking adjournment, the litigant should be more responsive, and it is the responsibility of the lawyers who are officers of the courts that they should not seek unnecessarily adjournment. And it is responsibility of the judge also that the spirit of the law and the letter of the law is implemented. When CPC itself provides that maximum 3 adjournments will be granted without a cost, and thereafter if adjournment is to be granted, heavy cost should be imposed on the parties. Why that process is not being done? So there are many such questions. So what I'm saying, it's a question of systemic failure, and enforcement of the existing law is more important than going and making more laws and adding more burden on the judiciary with regard to adjudication of all those disputes which will be arising under the new laws which are being enacted. Why can't we consolidate these laws? The process of consolidation has already started. In the labor laws, you have already more than 50 legislation. There are 4 codes which are being, labor codes which are being created by the government to ensure that there are lesser laws and people have to refer to lesser laws. Take, for example, crime against women and child. How many legislations are there which deal with crime against women and child? Why can't you consolidate all these laws and have a consolidated procedure for handling these matters so that judges as well as the investigating agencies also know where the limits start and where the limit ends? Probably, I think it is a concerted effort of all the 3 organs. And Mr. Mishra raised a point about compounding. Let me say, I mean, in Keshwanand Bharti case, all of us know that it has been said that separation of judiciary is the basic feature of the Constitution. So in case of cases are to be decided, the power lies with the judiciary, and it's not the executive if given that power. Probably somebody can question us tomorrow saying that the basic principle of the basic feature of the Constitution has been violated. So I think we had a wonderful discussion. Certain issues have been raised. Probably that has given us a food for thought, and all of us should consider it. And maybe in any other seminar or webinar or discussion which we are going to have, maybe we can talk about the legal education also. Mr. Mishra raised a very valid point with regard to Mr. Santosh also raised a very valid point about the legal education. There are colleges, I can say because I'm now associated with some of the educational institutions. I find some of the educational institutions, because of that teaching they are providing there, are producing excellent lawyers, excellent judges. But majority of the colleges which have been given recognition by the Bar Council of India don't have even the basic structure like library, forget the teachers. And the teachers who are recruited, what they are paid, all of us know. So probably let us not talk on this platform. Probably we need a separate discussion for that. With that, I conclude my observation.
Yes.
Thank you all the panelists for giving their views, and thanks to the organizer for giving me this opportunity to share my thoughts on this platform. Thank you very much.
No, sir, it's been an absolute pleasure listening to you also, and everyone. In fact, Shivakant sir also explained everything in so much details, citing individual experiences, and there is a lot to learn. I hope every panelist got the opportunity to do so. Mr. Santosh, you want to say something?
Nishank, I have one
Yeah.
request with all the panelists. If they have time, they can come to our next session on the second. They can hear the panelists, and after that they can go for question and answer, or they can answer the questions. And if they have time, they have that privilege.
As in, you want them to do what?
I want to. Actually, they can watch the show, and the panelists will go all around. They will make their speech, and they will deliver their speech. After that, P.K. Malhotra sir and Shivakant Prasad sir, B.B. Mishra sir, P.K. Mohapatra sir will be there to answer their questions or raise any question from the panelists if they desire so.
Yeah,
Totally
obviously I'll send them the link for the
hectic season you have made, a day-long season.
No, I will get back to them also. Obviously, we'll share the link, but I understand that all of us have our own time constraints, and we'll see if that is possible or not. But the fact that they all joined and they've spoken so extensively and in details is what matters the most. Obviously, we'll be taking this forward. It doesn't end here. We're preparing an outcome document out of this, which supposedly goes to the Indian Law Ministry, and we'll try our best to, actuate whatever happened here, effectuate it, right? So let's see if they can join in. That though they only know. I will send them the link on my behalf. But it was a pleasure that they joined right now. And P.K. Malhotra sir, do you have anything to say? I see your mic on.
No, Nishank, my apology. I won't be able to join because sitting in front of the screen continuously for 3 hours, I mean, that itself was too taxing.
Yes.
But anyhow, I mean, I enjoyed the discussion. It was really wonderful. The thought process which has gone is really, I mean, given a lot of food for thought also for all of us.
Right.
So my apology, I won't be able to join. Let me.
No, absolutely.
I would like to be excused.
So it was a long shot. He had to take it. I don't mind also. Right. Okay, and we'll go to Mohapatra sir. Sir, your concluding statements, and we'll try and keep it short. Wait, sir. You're not unmuted right now. Yeah, please go on. Yeah.
I have to add just 2 more points into what I said in the beginning. When the DRT and all the facility was provided, including the SURFACE, there was a framing of a timeline also was attached to it. Like a DRT had 180 days.
Right.
When a SURFACE case is going to DRT, it is 4 months.
Right.
But that is all gone for toss. So then, is it not time to have a rethink over it? If it is not adequate, what should be the exact timeline? Because unlike the individual cases of money suit, a criminal case or a dispute, family dispute, etc., this is for a national cause. The banks are staying robust and healthy is ultimately a big benefit to the economy of the country. So it is time to revisit these timelines and make the DRTs, tribunals, even the NCLTs time bound to decide on the cases whereby the delivery system will become more powerful and effective. That's what I would.
Right. No, and thank you, sir. You've kept your points very concisely. I mean, it's just not the quantity and the quality that matters in the speech also, not just in judgments. So I like the way you presented your entire thing, especially with all your health concerns. Thank you so much for joining. Mr. Sanjay, do you have anything to say? We'll take the last word from Mr. Shivakant. I'll unmute you. Just a second. Try and unmute yourself now.
हम हिंदी में ही बोलना चाहेंगे भाई.
हाँ बिल्कुल बोलिए सर.
ऐसा है कि जो विधायिका है, जो लेजिस्लेटिव है, उसके तरफ से यह बात उठती है कि जो है न्यायालय धीरे धीरे शक्तियों को अपने अंदर संग्रहित करता चला जा रहा है। जो 1980 में कपिला हिंगोरानी जी ने जो केस किया था, जो है हुसैन आरा बनाम बिहार सचिव के माध्यम से पीएन भगवती के जो कोर्ट में केस हुआ था, जिसमें 40,000 लोगों को छोड़ा गया था बिहार से जो कैदी थे। तो उस समय से जो पीआईएल धीरे धीरे दाखिल होने लगा, पीआईएल के माध्यम से क्या हुआ कि इसमें जो है न्यायालय धीरे धीरे शक्तियों को अपनी तरफ खींचने लगा। ये लेजिस्लेटिव का कहना है। और जब वो अपनी तरफ शक्तियों को खींच रहा है, तो जब शक्तियां उसकी तरफ जा रही हैं तो कार्यभार भी बढ़ रहा है, उसका कार्य भी बढ़ रहा है, जो कि ऐसा नहीं होना चाहिए था। जो भंडारी गाइडलाइंस आया था 2010 में, उस हिसाब से पीआईएल का मैटर जो है, जो सर्वोच्च न्यायालय को अधिकार दिया गया है सूची 32 और उच्च न्यायालय को दिया गया है सेक्शन 226 के अंतर्गत, जो रिट का मैटर रहेगा, रिट के मैटर में जो मानव अधिकार का मैटर रहेगा या जो राज्य बनाम संघ का मैटर रहेगा, उस मैटर में ही विशेष प्रकार का हस्तक्षेप करने का। लेकिन क्या हुआ कि जो पीआईएल दाखिल होने लगा, आज भारत में पूरे उच्च न्यायालय और सर्वोच्च न्यायालय में देखा जाए तो 10 से 15% मैटर जो है केवल पीआईएल का है, जिसमें जो है जुडिशरी का बहुत ज्यादा समय जो है व्यतीत होता है। इसलिए जो है पीआईएल भी एक मैटर है। फिर एक अदृश्य
Sir, I'll stop you here. We'll get to hear from you in the third panel. I know this is going in the speech direction and we have to end it. We've already crossed the time limits. I'm sure the second. Yeah, you can just make a concluding statement and after which I need to.
मेरा यह कहना है कि जिस प्रकार से न्यायालय अपनी तरफ शक्तियों को खींच रहा है, तो शक्तियों को खींचने का मतलब यह है कि उसके ऊपर भार भी ज्यादा पड़ रहा है। तो जैसे पीआईएल में अमेरिका में एक सिस्टम है कि भाई जूरी सिस्टम है, जो सामाजिक न्याय के मामले होते हैं उसको जूरी के माध्यम से और सामाजिक कार्यकर्ताओं के माध्यम से उसको सेटल किया जा सकता है। तो कुछ चीजों को जो है अपने न्यायालय को भी इस प्रकार से सोचना पड़ेगा,
इनहेरिट करना चाहिए। बिल्कुल।
कि जिस प्रकार से जो है उसके भार कम हो, और उसके लिए सरकार को इंफ्रास्ट्रक्चर भी बनाना चाहिए। 2018 में एक जुडिशियल अकाउंटिंग का केस भी आया था, जिसमें सीसीटीवी कैमरा के माध्यम से केस किस प्रकार से चल रहा है, क्या उसमें वाद प्रतिवाद की सुनाई हो रही है, वो सब भी चीज होना चाहिए था। लेकिन अभी सरकार उसको भी नहीं कर पाई है। तो सरकार इंफ्रास्ट्रक्चर भी नहीं दे पा रही है, और जो जुडिशियल हमारा सिस्टम है वो अपनी तरफ शक्ति को खींच रहा है, इसलिए उसके ऊपर भार
right. No, that's well pointed. You're talking about the executive and we've discussed it in great details how the things have been fluctuating. I think P.K. Malhotra sir also talked about the separation, doctrine of separation, in terms of executive, legislature and judiciary. The last word from Mr. Shivakant, who had an extensive say on and gave us really a grateful insight, a great insight actually, and about all the issues. Yes, sir, please go on. We'll conclude the panel now.
क्या आपने पूछना चाह रहे हैं आप?
नहीं, sir, just if you have any last comment.
Just PIL, so far as PIL is concerned, by process of PIL, actually the the judges are exercising the what is called the duty of social engineer.
Right. Judicial activism.
Roscoe Ponds has said that the lawyer should be social engineer. So that is what you have provided this power. You have invited our attention to undertake this situation.
Absolutely.
Absolutely. There is a murder case. Sometimes whether it is a murder or is a suicide, politically motivated matters. All these are placed sometimes before the PIL court. Why it should be done?
Yes.
Is it not the litigant who is responsible for it? Absolutely. It is the court who is asking for the power or inviting that you file cases before me.
No,
it's not so. How many cases are there that the courts on so motor have they have taken cognizance? In so many cases we have I have taken cognizance in one matter.
Was
placed before the Chief Justice. Regarding the destruction of what is called, there was a reporting in the Sunmark with regard to expiry dates of the medicines and how
Okay.
lot of monies they are vested. So
Right,
that
right.
I had taken cognizance
Right.
on my. So that was
Right.
only one in
Absolutely.
kind
Yeah,
in
yeah,
my judicial lifetime.
yeah.
So it's not so that we want power. The judiciary wants power. It's not so. The judiciary independent. It's
Yeah.
we have to lead a very saintly life. We
Yeah.
are just like a hermit in the society or just like a widow. So we are if somebody we mix. You are looking after me, where I'm going, where to whom I'm talking, and all that.
Right.
So
Right.
we have to discipline our life. Throughout life, we have segregated. We are unfit for the society now, you can say.
No,
So
absolutely, absolutely, absolutely.
that's why
Thank
you
you.
don't. So
No, right.
PL, as Mr. Upadhyay was talking about PL, that we are asking for the power. No,
Yeah,
it's
yeah,
not so. You don't come
yeah.
to the court. Who has
Right.
asked you to come to the court?
Right. No,
You
no,
are
no.
because the executive is showing in action.
Right, right.
Legislature is also indifferent.
Yep.
That's
Yep.
why.
Right, sir. Right.
I was talking about that you are framing
Yeah.
the laws unnecessarily, and the
right.
infrastructure you are not providing.
Right.
You are providing the Electricity Act, which was enacted, and thereafter you asked for the tribunal. Tribunal was not constituted. It was the district judge who has to take the has to act as electricity tribunal.
Right. Right.
Like your POXO case, then your NDPS cases, like that. Holding the sessions cases,
Right.
again the NDPS cases are there.
Right.
So
Right.
they are also dealt with as if they are sessions cases.
Yep. Yep.
It was very harsh punishments are there. And
Yes.
in commercial cases, there is no provision for granting bail.
Right.
So
Right. Yes.
you ask
No,
for
we've covered that in details also, and you're right in the sense that you talk about judicial activism, and that is it. I think from panel one, all of us got a good insight, and Mishra sir was the special interjector. He kept pointing out the observations and questions. Mohapatra sir, thank you for covering the financial aspect, and Shivakant sir, you covered everything about especially the judiciary, in great details. I don't think you can have that knowledge by just reading something or a book or something like that, because until and unless that someone is there who has actually been in that place and practically experienced it, it is difficult to have such an understanding. So thank you so much for that. Former Raw Intelligence Officer, Vice Chancellor Nirmal Kanti NUJS, they are maybe still yet to join us. Maybe we'll see them in panel 2. They were scheduled for panel 1, but this is it from our side. We'll see you in panel 2 that starts in about 40 minutes. Thank you so much for joining.
Ajab, Mr. Host, I am telling you one thing.
Yeah.
Just what we have was that there was a technical glitch,
Yeah.
that Vice Chancellor could not join us.
Okay.
Early.
Yeah.
He could not make his deliberation.
Right.
This is what is the problem in the e-courts. And we have faced all these things.
Okay. Yes,
so
yes.
We should not compare with Malaysia, Singapore, US, and all these places. Our population and our cases, our mindset and the laws are different. Our parliament is different. Not like that. So we should never compare with them. What infrastructure they do have, we don't have. America has got 107, 108 judge per million. We are not having that. We are having only 20, even less, I should say.
Yes, sir.
Whereas the Supreme Court already in All India Judges Association pointed out that it should be 50 at least, 50 judges. So where is the 50 judges? So you go to the CGM court in Alipur.
Sir, I don't want this panel to end only. To be fair, I want to continue the banter.
You go to every court and see what is going on. You can see the lively what is going
Absolutely,
on, how they are busy, and thereafter you look into their life also, that what they are doing in their house.
Right.
You just see this library which behind you find this is not my library, it is the Honorable High Court which has provided to me.
Right.
So I have retained it after my retirement.
Right. No, sir, absolutely. And different stakeholders of democracy are here. That is the whole point of having this. I don't feel that independently a panel discussion of this level actually happens, And I love it, the counters that are coming constantly from Mr. Shivakant, B.V. Mishra and P.K. Manotra also, and Pradosh Kumar Mohapatra sir kept his points very concise. Thank you, Mr. Santosh Sanjay also. also for joining. I can again see Mr. Upamanyu. Thank you for being on the video thing of this. We'll see you in next 30 minutes with our panel 2. Thank you so much for joining. We're closing this meeting now. Are you trying to say something, sir? We'll end this. Thank you. Thank you. Since we started the recording now, I'm just going to reintroduce and say that Kanksshi is the founder of Netri, India's first incubator for women in politics. And the topic is the same, the pendency of cases and its socio-economic and legal implications. There you go, Kanksshi, you have the dice.
No, thank you so much. One, for inviting me here, and also taking this initiative, right? Like, it's so important that these discussions are ongoing. Second, I do not come from the law background. So just a heads up for everyone here, that's not the background that I come from. It's been my fortune that I've engaged in the parliamentary processes in the past, learned through drafting legislatures with other lawyers. Where I come in is the intersection of understanding the role of public policy, legislature, but ultimately also the society in the participatory democracy that we live in. I would like to believe that we still do. So like, on to where I come from, in the sense that my thought process and the work that we do. So Netri Foundation is a political incubator and aggregator for women making careers or finding pathways to enter politics, sustain in politics, and figure out how can they shape the public, the public discourse and also the political outcomes of a democratic country like India. So this is Netri Foundation's work. One of the things that has stuck with me growing up in this country is largely the absence, the abysmal representation of women in public offices across. Beginning with, and let's take, like, as you know, very insignificant but very prominent public offices, like, the peons culture, the if you have to speak about police, if you have to speak about all public institutions, be it judiciary, political offices, and also within that the hierarchy and how it flows. Indian Administrative Services has done a good job in inculcating a lot more women, but if you look at then the procedures of the selection of such a of such a cadre, right, of the IAS cadre, it is such a hectic process. How many women actually also end up making that? So this funneling that we completely and constantly talk about, that women want to and do enter workforce, but then there is a large funneling that happens by the time it goes to the leadership position. And this is true across not only public offices, but also private. Now, the benefit of the private is you can always dangle the carrot of economic outcomes, the ROIs, and you're missing out on so much of GDP contribution and economic contribution, and why don't you have more women in? You can dangle it there. However, there are very less incentives we have seen in the public offices for women to be included. So there are multiple approaches. There is one right-based approach, right, that women should be and must be a part of all these places, because ultimately the decisions being taken impact the lives of the women, who are also 50% of the population. But having said that, there is also the second argument that flows in is not only the human rights approach, but also that when they do sit on the table, they bring in different perspectives. So now that's a constant comparison that we find ourselves in. Netri's work and tying it back into something that we're discussing today, which is the pendency of cases. I'm sure that like lawyers don't need me to run down on the pendency that has been staring us, glaring in the face of this country. Very recently, I think it was Kiran Rijiju, the minister of the Union Minister of Law, said that this kind of pendency is bothering, and post-pandemic, of course, the time the timeliness of solving cases, resolving cases, pendency. It was all in a big mess. Having said that, how does it impact the life of the last woman? And that's exactly what I think about anything happening in the country. That when women are not sitting on the decision making tables, when women are not a part of the decision making, but here in this case, and these are some figures that I was able to find out, that when there are matters which are pending, amongst that, if you have to look at 88% of the cases are pertaining to crime against women. This was recently in Telangana, if I'm not wrong.
Right.
Yes.
Yeah.
And the second one is also, if you look at the access to the justice system itself. Now, I am not going to be, this is not my place to say that because there are no women in judiciary, women can't access at the bottommost level. The plight of the women to not be able to access judiciary is not only with the fact that there are less women judges and less women in the courts, but it's also to do with how many women are criminal lawyers, how many women also make professions that enable that access, how many how many of us actually know the breakdown of the law, and it could very easily be drilled back to education. But I always feel that इतना तो सबको पता है कि आप किसी को कोर्ट ले जा सकते हैं. अब वो कोर्ट ले जाने की जो प्रोसेस है, women like disproportionately do not have access to that. So that is why of the pending cases, if you also see that the only 10% women are the litigants, right, who have filed these cases. But at the same time, the cases that end up getting pended, तो ये अगर हम दोनों को evaluate करेंगे कि वैसे औरतें इतना कम उसको एक्सेस करती हैं, जो औरतें एक्सेस कर रही हैं 10% अगर हम मानते हैं लिटिगेंट्स हैं विमेन, और जो फाइनली जो केसेस पेंडिंग है उसमें से 88% तो वो विमेन के क्राइम के अगेंस्ट है. सो यू आर सीइंग दैट how few women are able to access the system, and then ultimately the cases that are pending are pertaining to women. Now this story, it's in itself is very strong to say how it impacts the socio-economic, political, everyday survival life of a woman at the last mile, right? अगर आप एक बहुत ही dangerous domestic violence की situation में हैं, if you're somebody who's directly impacted by sexual harassment, if you're directly impacted by DV, if you're directly impacted by standing to lose a job, if you have almost like put up a posh case against your employee, you are constantly losing out, because you will not be in the office, you will not be working, you will not be hired. The impunity that the perpetrators or the people who have been accused in the case enjoy during the time that the pendency is existing, it's almost like a subtle mental torture. Having said that, because I do not come from the space of law, but I understand that the implication of participation in all the processes that make law, be it the judiciary, be it the of course like judiciary, legislature, and the executive, the policy and the law space does not see the urgency to do something about the women's matter, right? So I think I would put a stop to that here, but open to just, of course, like listening and discussing more about this.
Right.
But thank you so much, Nishank. If you do have a follow-up question, happy to answer.
Yeah, I do have a couple of follow-up questions, but okay, so we also discussed about this lopsided inaccessibility that women have in politics. Also, we see the same in judiciary. I think there are a lot of reports on this also. Even the UNODC has talked about it. Why do you feel, look, you've been talking about inclusion of women, okay, and that's something that even the CGI has mentioned. I think he even went ahead and said that there is a need for 50% reservation and so on. But like, do you feel that this is to offer a gender neutral perspective? And why are we only talking in terms of he and she only, but like other genders also? I mean, if gender were to be a factor, not just men and women, but more of that. Like, if you could shed some light in that.
No, completely. I think, as I said, there are, and in academia, because I come from academia largely, there are ways to look at reservation or ways to look at for advocacy of inclusion. As I say, one is a human rights approach, that why not? Everybody just has the right. You have to make some, you have to put some protective mechanisms in place, give more access, all of that. The second one is, how does it benefit, right? Like, so you always have that angle, that why is it important for women to be there, to make it accessible for other women to approach and take advantage and leverage the institutions that are put in place precisely to serve them. So that is second. Third, when you say, it's also to do with, when you have that kind of diversity, you're still existing in a secular democratic republic. You're able to serve your people better, right? And making gender redundant would be the call, right? At some point, and I think this is the feminist argument, that at some point, gender should become a matter of personal performance. It is not to do anything to do with the public performance. My opportunities, the work I do, how I conduct myself in public should and must not have any bearing on who I am identifying it with my gender. And absolutely right, we did start with a 33% reservation. We notched it up to say that because women are a 50% part of the population, and it is like looked at in very binaries, that it's the male and the female, that we are 50% of the democracy. But when we define women, we say it's not only assigned female at birth, it is also trans women, it is cis women, any person who like mostly aligns with that. But definitely there must be a lot more discourse on what does it mean for people who are gender non-binary, who do not identify with a single identity per se. Having said that, we also need to understand what does gender neutral means. Gender neutral does not mean it is the absence of the gender. It is to say that you design for the last person. And we were talking about this, and let me put that point across. The other day we were talking about how products, and like let's take tech products, policies, laws, when they are designed for men, they are by nature exclusionary. When you design it, and in India, like think about all the intersectionality that you design it for the disabled, tribal, Dalit, woman, child. By that, you will anyway make systems inclusionary. Think of a park, a public park that should have a slope. It's not like an abled man can't walk a slope. But if you will only have stairs, an able man or woman or child can't walk it, right? Like a disabled child, man, woman can't walk it. When you design for women, when you design with that gender disaggregated approach, you design for everyone. But when you design the way we have been designing the world, which is exclusionary, is because you design for a certain category of people who have taken those spaces. As you will want to take more people's take space, we talk about infrastructure. We talk not only about physical infrastructure now, we talk about the digital infrastructure, the algorithms, the way they are trained, the ML, how it is trained. If you will not feed it women and women of color and women of a certain race, it will never learn to recognize it. Facial recognition technology has one of the biggest disadvantages, that it almost refuses to recognize people of color, women of color, people of a certain race. So it is a matter of design. And we are in the, ultimately through law, through public policy, through politics, we are in the constant process of social engineering our society, right? And we are in the constant process of designing and redefining it. So if you will design with that lens, you are likely to never go wrong.
Right, absolutely. I think you're just not talking about the symbolic perspective that would come in. It is obviously moving towards a genderless society. Or also, apart from that, what the role can implicate. You know, the lens through which the judgments come in are also critically important. I will move on to the other panelists. Thank you so much for joining, Kanksshi. And if anybody has a question for Kanksshi, they can ask right now, and we will switch. I understand that you have other commitments as well. So,
yeah, no questions also, but I'm happy to just listen to
yeah.
any comments if anybody
Yeah,
has.
if anybody has to say anything,
Yeah,
they can
anything to
please
say.
go on.
Thank you so much.
All right. Thank you so much, Kanksshi. It was great. Okay. After this, we will be having just a second. I'll just pause for a second because I've been receiving constant calls from. Will Advocate Sudhir Tiwari be joining, because he was supposed to be the first speaker?
No, he is not joining due to technical glitch.
Okay.
Being a old person, he don't know how to operate.
Yeah, no worries, no worries, no worries.
So,
Okay. Okay, next up, we have Mr. Alok, and he's a senior advocate. He's done his LLM from Ohio, United States of America, and he's got a lot to add because he's defended so many cases, especially when you're talking about judiciary. You know, the Abu Salim case. He's famous for that. Mr. Alok, you have the dais now. And we will just, in case you have any questions to the other panelists, you can just raise your hands and we can go ahead with that. Mr. Alok, please go on.
My topic, which to my understanding is regarding the pendency of criminal case or cases in Indian legal system. Now, I think this entire issue of pendency of legal cases, or, there's lots of noises made about this pendency of legal cases. We don't have a system of specialized cases, like when a judicial officer joins a judicial service, he is not given an option that whether he would like to do during his course of service, whether he would like to deal with civil cases or criminal cases. We have a judicial officer who will be dealing with civil cases, he will be dealing with criminal cases, he will be dealing with rent control cases, and he will be dealing with accident claim cases also. So now this brings us to a very important question, that when there is no specialized knowledge, when there is a lack of specialized knowledge in the presiding officer of the judge, then this backlog happens. Suppose a judge is very well read in criminal law, he would certainly not like to do civil cases, and he'll adjourn the case. Okay, you do whatever you want to take whatever date you want to take. But once you create a specialized court, then this entire question of adjourning the case which is not of your liking goes. One thing. Now that once you create a specialized court, then what happens is that there is a consistency. You can catch the judge that where you have deviated, why you have deviated, and if you have deviated, then the higher court can always say that this is not the correct approach of the law. We correct you. If you commit the same mistake, either we will assume that it is because of the corruption or because of some oversight. So there is a strong system of check and balance which is placed once you create a line of specialized courses. So a man is dealing with civil cases throughout his career. As a judicial officer or as a lawyer, he will immediately grasp the issue, and it will not take more than few minutes to grasp the entire case, what it is. Whereas if he is not, then he'll take years and years together, and he'll just keep on delaying the things. Second thing is that our courts are so overcrowded, lack of infrastructure. I was hearing the other panelists few hours back, something from Bihar. So 4 cases get adjourned, or 50 adjournment cases, 50 dates for a case was adjourned in a matter of, I think it was Prevention of Corruption Act. You see, the person who is going to the court, every day you see that there are 10 witnesses coming in 10 different cases. Now there is only one presiding officer, one reader who is going to type, one reader for civil and one reader for criminal. And there are 2 typists. in a criminal case where life and liberty is at stake, a judge cannot afford to, divert his attention while the evidence is going on. So obviously, when he is taking one witness, other 4 cases will have to take the back seat. Though other cases will have to be adjourned for some other date. And this process is an ongoing process. So you say that because there is a judge is not going to adjourn the case, no, I'll take the case, whereas he is taking evidence in other case. Now, what you do is that you hold up a lawyer, then the poor lawyer is sitting in your court and he is wasting his time. Instead of attending some other case, he is now fearsome that this judge is not going to adjourn the case. Now I am held up and cost will be imposed or whatever it is. So he cannot go and attend to any other case. And he is held up there. So this kind, you need to understand that unless and until you create a proper infrastructure, you increase the number of judges. And I say you employ n number of judges, this pendency will always remain. Can you imagine a situation where all the cases are solved and then what will you do with this entire huge infrastructure? Then there are no cases pending. What will happen? Everybody says that, justice delayed is justice denied, but justice hurried is justice buried. That is also thing. Many times what I see in session trial, judge is in hurry of closing the case. 3 years prosecution has taken to examine their witness and he is not willing to give 3 months to the defense to examine their witnesses. You bring all the witnesses. I am not going to issue summons. And in hurry, he'll deny the opportunity to the defense to examine their witnesses. I'm sorry.
No worries. Go on, please. Yeah.
I'm sorry.
Yeah, no worries.
This is one problem.
You have stopped for us. Can't call him senior. Alok sir also, but he stopped for us. Can you guys hear him or is it just me that you can't? Okay. He's having a power cut. It's been there throughout. Yeah. This is also one problem for pendency. This virtual thing has made us realize. Okay. We have Anirban sir already here with us. I think Mr. Shovik was also here. The professors from NUJs. So bunch of NUJs people, because our Vice Chancellor was also here, which will be followed by the key speech by Mr. S.K. Singhi, who's the managing partner of S.K. Singhi Co. LLP. Let's start with Mr. Anirban and we can go to Shovik sir.
Nishant, former High Court judge will also join within a minute.
Yeah, it's all right. We'll take him on the dais as well. Thank you for letting us know. Anirban sir, please go ahead.
Yes, very interesting topic, but very, very complex. As Mr. Vagrecha was just saying, I hope I got his name correct. Justice hurried is justice buried. This is something which you'll find from most of the advocates who, we all profess that yes, it should be expedited justice. But in most cases, we find this expedition has created a problem. But be that as it may, today the topic is what is the socio-economic effect on delayed justice and the number of cases pending. Just for the time being, I would rather say that in delaying justice, the problem which is being faced is that there is an economic distancing being maintained for this. I'll point out how this happens. You see, let us say someone goes to court for a certain kind of relief, which he or she would be entitled to. But that can also be denied by, let's say, a respondent who would be economically far superior and go on taking adjournments and go on pushing the matter, so that at one point of time, you'll find that this delaying tactics allow coercion, which tantamounts to a person who has real rights being defeated in his rights. So this is basically the reason why it has to be looked into, that there should be an expedition in dispensation of justice. One point is very important that we must find out, and we must also try and establish, because as I was told that you are trying to send a white paper to the ministry, Another thing is that the number of judges. Alok was saying that number of judges would not really matter, but I would differ because you see today in the high courts as well as the Supreme Courts, let's say I've just taken down certain numbers. There is a total strength of 1,108 judges, considering the huge teeming millions and crores of population we have in this country. Just consider 1,108 judges of the high courts and the Supreme Court. That itself is baffling because that creates the rift. Now, out of that 1,108, at this point of time, there is a vacancy of 381. So as it is, the numbers are not too much. And of that, we have 2/3 working. So this would definitely create a problem because if you do not appoint judges, it would tantamount to the dispensation of justice being delayed. You see, as we increase in population, the numbers of litigation tend to increase. And that there is no dispensation in an expedited manner also hits the commerce of this country. Now, we have been trying to, taking separate routes, trying to do away with this delay by tribunalization. We have tribunals which are failing. There also you'll find that there are several matters which are pending. So what Mr. Vagrecha was saying about specialization, yes, it's a good thought, but I think it has failed. Because think about the company law tribunal, think about the other tribunals, you'll find they're also teeming millions waiting there for dispensation of justice. So this creates another problem as to whether tribunalization will give us that. But at the end of the day, we lawyers must also take an attempt and make an attempt to change the system. Because yes, we are also a part of this system. We are delaying the matters. Sometimes we also take a call, okay, let's try and just delay it a bit. Adjournments should be, according to me, statutorily prevented, barred. A person who should be only allowed, let's say, a certain number of adjournments. And if adjournment is given, it should be on punitive costs. If you do not have these things, then there is no bar as such. Mr. Vagrecha, I had taken the liberty of moving in because we had this.
No, I informed him that already. Mr.
I'm so sorry.
Mr.
But I'm more or less over, so I'll just stop for one more minute and you can take over again. But I absolutely accepted what you said about justice being hurried and buried. I love that. So I think I was also saying the same thing. It's not about hurrying, it's striking the correct balance. But for striking that correct balance, I was trying to say that the number of judges needs to be looked into also. Because today, the number of judges are not proportionally increasing with the population of this country. It is hitting the commercial law angle also because people do not want to come here. Even for that matter, arbitration centers, arbitration seats are not, India is not the right place because you see, arbitration can end in an expedited manner. But again, if you end up in courts, there you go, it gets delayed. So these are things I think which is required to be seen. First of them is that the number of judiciary people, the judges may be thought to be increased in proportion to the population. Then the point is that prevent unnecessary adjournments by statutory laws in any way, also including punitive costs, if possible. It has to be in the mind of the judges also that in a hurry, they should not, as Mr. Vagrecha said, bury the law, because we are seeing this. Because I've been told that there is it's just a custom that there's a point system going on for the purpose of how many matters you have decided. So that shouldn't be the case in these kinds of situations. So according to me, I suppose there needs to be striking a balance with added judges on the board. Thank you very much.
Right. That's well said with respect to the quality and quantity both and striking a balance. But Mr. Anirban, you're saying that there should be a limitation on the number of adjournments, if I got that right.
That's my proposal, and that's something which, it's an attempt to stop adjournments because I, being a lawyer, I'm sure the lawyers who all are here, at one point of time, we have also employed this tactics of delaying the matter, haven't we? We have, but that needs to be stopped. I don't know how it's going to be stopped. Penal costs, punitive costs, maybe one side of it.
But
yes.
My question here would be like, who would put that number and like, how do you decide that?
That has to be a statute. in some way, the code of civil procedure or the criminal procedure, if there's a way of amending it. Because you see, there are limitations which are being created by laws, the timeline. But when we end up in the Supreme Court, most of the time we find that the timelines which are provided in the statute, they would say these are mandatory, not mandatory, directory. When it comes to the high courts, when it comes to the Supreme Court, sorry, I shouldn't be saying this, it becomes directory, not mandatory. So that aspect also, I think we need to look into. Okay.
All right. Now, makes a lot of sense. We'll hear comments from Mr. Alok after this also. But Mr. Shovik had also joined in. He was, about to speak after this. After this, we go back to Mr. Alok, and then finally, Mr. S.K. Singhi, who is the key speaker for the session. Thank you so much for your speech, Mr. Anirban. I am sure some of the panelists will have certain comments to make about it, because you've addressed certain points that Mr. Alok made. Yes, Mr. Shovik, you have the floor.
Very warm good afternoon to all who are here with us today, and thank you. My thanks to the organizers for making it possible for me to have this platform. Now here we have, since morning we are actually having a very lively discussion, and it's really refreshing to know about all of these different perspectives, both from the industry, from law people, from legal background as well as non-legal background. And I, as an academic, I believe that, as an academic who actually still retains some ties with the industry, I believe that it is of the utmost importance for us to figure out the exact pulse of the problem. And for that, we need to have these kind of sessions. And now the thing is that I've been hearing all of these different courses about pendency of cases and everything. And I do not disagree with the aspect, with the point that, if we increase the number of judges, that is definitely going to have some positive impact on the number of pending cases. But at the same time, I also agree with Mr. Vagrecha's point that, that's not necessarily going to make the system more efficient. Because if there is a systemic problem, and we have something, and anybody who is from science background, or for that matter commerce background, would be able to understand this, that if the system itself is inefficient, you can throw more resources and more input into the system, and it will still produce more output, but that won't make the system more efficient. In any system, whether efficient or inefficient, if you keep on increasing the input, then the output does increase, but that doesn't make the conversion factor more efficient. And that's why I believe that it is important for us to also figure out that because somewhere or other we circle and we come to those same points. This is a topic which have been being discussed ad nauseum for the last 20-30 years. What to do with this pending huge pendency rate increase? So major points we come to that. One, we come to the fact of that number of judges, and the second is lack of infrastructure. And these are very, very real, very real problems, absolutely, no doubt. But as someone who has been researching in this field, specifically involving pendency of cases and potential solutions, problems, identification of problems regarding the same, I will just highlight, I won't take a lot of your time, I'll just highlight 2 or 3 matters that we have come across. So the first thing is that there have been one very interesting point made about our comparison of how low per capita judges we have in our country. The thing is that we usually, most of the reports also about this, when they start comparing, they compare us with the equivalent position in the US and UK, the 2 jurisdictions about which we seem to be a little bit obsessed. And they say that, yeah, see, they have much more judges per capita compared to us. And that's why their situation is much better. As somebody who is engaged, who has an affinity towards economics, statistics, and mathematics other than law, I would say that perhaps we should focus on countries which actually have similar or comparable number of judges per capita with us, and then see what is the pendency rate there.
then only we will be able to figure out that apart from the number of judges, if there is any other contributing factor. That's fine. I mean, we can't, no matter how many meetings we have, how many discussions we have, we are not going to be able to convince anybody to increase the number of judges all by ourselves. That's a point matter which, it has multiple other factors involved in it. So we were, I mean, with some of my friends from University of Chicago, we had carried out a little bit of a basic pilot project. And we found out, in fact, we were just discussing something with one of our alumni from NUJS, so who is actually an exchange student. He came from Germany, and he is now a civil court judge there. So he told us that, in one particular week, if I have to give, say, I have to write X number of judgments, and subsequently in the appellate court, or say more than 40% of these judgments get reversed, then I will have to show cause for it. Why is it that my judgments are not being upheld in the trial court? Is this a problem with application of law? What is the situation? And so on and so forth. Now, and he said that because of this system, the application of law in the lower court in Germany has become more efficient over a period of time, as a result of which the number of cases which are reversed on appeal there is actually much lesser. And this started making us think, and we carried out a very small pilot project of Calcutta High Court's, just 1 year of cases only in the appellate jurisdiction. And what we see, the thing is that if we assume as a hypothetical position that large number of cases in the lower court level, the law that is being applied is being incorrectly applied. Let us make that assumption for a second. Then what essentially does that mean for the lawyers and the clients? So if I know that, chances are the law has been incorrectly applied, and if I appeal, the judgment is going to get reversed, then every lawyer, regardless of whether he wants to make money or whether he is very genuinely concerned about the client, will advise the client to go and appeal. But on the other hand, if I find out that the trial court judge has applied the law perfectly, I mean, it's a watertight judgment, then the chances of that getting reversed in appeal is very less. On an overall number, lesser number of lawyers will actually advise the client to go forth and file an appeal. Now, if that is the case, then we found out, I'm not going to the in-depth analysis of that study, but we found out that this is a big problem insofar as high courts appellate case pendency level. There is no reason why that many number of cases should be filed in appeal at all before a high court if proper application of law is taking place on the trial court level. So we came across this matter, and of course, this is a very pilot project and analyzing only 1 year's data of one high court. Our overall idea is to come up with a proper grid which will have data about all the high courts and Supreme Court level about this. And it will also help us identify that if in certain specific courts, certain specific categories of cases are getting overruled, whether it is necessary for us to actually spend more time in in training the judges from that particular area in those kind of cases. Why is it? I mean, a judge deliberately does not misapply the law. Maybe there is a lack of understanding of law, or maybe multiple factors can be there. But for the purpose of even trying to figure out what those factors are, we need to first carry out this kind of quantitative data analysis. And the judicial data analysis, even in the presence of National Judicial Data Grid and all, they're doing some good work, but it is by no means enough. There is no quantitative data which supports any kind of decision analysis on this kind of level in our country, which is one of the major problems, the lack of empirical studies. So I was also, discussing with a few of my friends from Flame University and others who had carried out a basic analysis of trial court data based on the judicial data grid statistics and others. And they came across some very interesting results. One of them is that, let us assume that, they had done it mostly on a trial court level. So they said that there is no case-specific pendency rate. I mean, it's case agnostic. So there are certain areas wherein the pendency rate in trial court level is very high. And these can be outliers actually, maybe it's not a state-specific thing. So there are certain states which might have very, I mean, comparatively lower pendency rates, but within those states itself, certain districts, certain specific trial courts are having very high pendency rates. And they try to figure out what is the case. It can't be the case scenario of, I mean, what is the scenario that there are two trial courts which have comparable amount of resources, comparable number of judges. In one of those, pendency rate is really low, in the other pendency rate is quite demonstrably high. It can't be a case of mere application of resources. They also found out that it's not necessarily a case of, of course, on an overall basis, criminal cases remain pending more than civil cases, as per any kind of studies which has been made. One of the major reasons, of course, is that unless and until all the parties are actually present in most of the criminal cases, the court cannot actually proceed with the matter much, which results in a lot of adjournments. And there have been some very good points made about adjournments by my previous speakers. And I was actually having a very interesting. I was part of the audience when two of my friends were having a debate. One of them is a lawyer, and the other one is a judge. And the both of them are essentially saying that the judge is saying that, but lawyers keep on asking for adjournments. The lawyer is saying that, but then the ultimate decision rests with the court. If the court doesn't give adjournment, the lawyer cannot snatch adjournment away, right? So, I mean, if you are giving adjournments over and over again, then certainly you will have to shoulder at least part of the responsibility. And then the judge started saying that, but if adjournments are not regularly given, then lawyers from that court will essentially start protesting. They will call for strikes against that particular judge and so on and so forth. And then the lawyer said, but then essentially that means that you are taking the easy way out. I mean, if you're doing your duty and not giving an adjournment because you think adjournment should not be given on that matter, after that, the repercussions are something which are part and parcel of the job. So if you don't want to have those repercussions and you're taking the easy way out, then that's fine. That's your call. But that doesn't mean that you can be absolved of the responsibility of giving those adjournments. And so these are very interesting factors as such. And one aspect of that is, I mean, apart from using the trying to figure out these systemic problems, another thing which I am engaged in, and we are doing some work with multiple IITs, IIT Kanpur, Kharagpur, Delhi, IIIT Hyderabad, IISER Kolkata. So we are at NHS, I'm personally having all of these research projects involving application of AI and legal technology in the legal domain. And what we are trying to see is that whether it is possible, the purpose of, I mean, regardless of whoever tells you otherwise, AI is not here to replace lawyers or judges. That sort of AI is not going to be a technological reality in the next 30 years, at least. So what is, I mean, what is the focus? I mean, what's the focus? What is the objective of this technology? It is to how to help the judges and the lawyers do their job in a better, more efficient format. Can be of helping in research, can be caseload management softwares. And there are caseload management, application of AI in caseload management is something which is now being used in multiple other jurisdictions. Even in India, we are working with a couple of state governments to help to come up with that kind of a dashboard, which will be useful for this. Supreme Court itself is using at least two known AIs in the Subhash and the Supesh initiatives. It's one of which is caseload management, the other is translation or translation of software. So, there can be technological solutions. What we find out is that big problem is that there are a lot of tech people from tech background who are really interested in solving these kind of problems, but they need lawyers' help. Without that, they can't do anything. They don't know the law. They don't know the problems. And there are very, very few lawyers or legal academics who are actually really interested in this domain to give any meaningful input to these kind of people. And one of the reasons is that lawyers, despite the fact that we work with probably the highest range of different kinds of sectors, there is no sector in which lawyers don't work. But at the same time, when it comes to the law in each of these sectors, a lot of lawyers, no reflection on the present company, a lot of lawyers tend to be very territorial in nature. They think non-lawyers should not encroach in kind of legal domain and such. And this is the input which I have got from non-lawyers who are interested in working collaborative projects. Actually, they say that lawyers don't think that non-lawyers can actually help in any way in solving legal domain problems. So yeah, I mean that's been a problem. But I think One of the ways to sort it out is, of course, young people, young lawyers, both in young lawyers as well as young practitioners as well as young academics, who will have maybe a little bit of less prejudice when it comes to telling people that law is not a very jealously guarded domain or anything like that. By all means, because this problem is not only a legal one. There are legal problems. As my previous panelists were making raising questions, that there can be statutory changes limiting number of adjournments and trying to figure out some way in which cross-examination can be limited to a certain point of time. So there are multiple legal solutions which can be found for this. But the overall problem is illegal. The overall problem is very much, there are social aspects of the problem. There are infrastructural aspects, technological aspects, and so on and so forth. So one of my students who has graduated from our university in 2019 is successfully running a startup now, which is pioneered in the field of online and alternative dispute resolution techniques. And they are now working with different state governments to occasionally hold these online lok adalats and other different kinds of online in ADR things, by which they have made a fairly decent dent as one organization into this entire scenario. So, and this is all coming from young minds, actually. Young is, of course, a relative term. A person can be 50 and still behave like a young individual. But the fact remains that, these kind of, the more we actually, since the problem since the problem goes across multiple disciplines, the answer has to come from multiple
disciplines. Yeah, no,
it cannot be a one simple piece of time. So more focus on actual quantitative data. And this, even for data, there is a reason. I don't know here anybody is from stats or economics background. They would understand that if we just see some data about cases or anything like that about pendency in tables, as compared to that, we make a grid. We may actually make a better visual representation of the problem and try to see that whether there's a spatial problem, as in across the country it is happening, whether certain specific cases are actually happening more. Simply better representation of data can help us understand the different aspects of the problem much better. And this is what I have been trying to encourage empirical decision research in our students also, and I think this will help. If a combination of these things can happen, some of these problems can at least be sorted out.
Absolutely. That is the points are very well made, especially all the projects. That is why every speaker is so unique when they come to this dais, especially the part when you brought in about the projects. And also, do you mind naming the startup, the one you're talking about, if you remember?
It's called SAMA, SAMA. SAMA.
Okay.
So
it deals with online arbitration.
Online dispute resolution mechanisms. They had started something called the Indian Mediation Week, which was taken up by the Justice Department. And a lot of media, they were essentially popularizing mediation as a possible technique among small scale traders and for small scale commercial dispute resolution systems. And it worked. He started very small. He just got 7 or 10 students, and he would regularly to the Shialda market, which is fairly close, and he would throughout the day he would talk to these different traders and say that you have this dispute, why are you thinking of going for court? You can sort it out by way of mediation. There are trained mediators, we can help, and the language issue will also be sorted out. So eventually they scaled up, opened I think 23 chapters all across the country, and that's when we realized that this can be something of importance to the judicial department, and the Ministry of Justice took up his project, and subsequently he went to I think Harvard Business School also called him up as a case study of his entire thing. So it works out, it adds up.
No, adds a great sense of value to the panel as well, because we've been talking about problems all day, but it's good to see that youngsters are coming up with the solution. You always look to a combination of both expertise and youth, especially when you're dealing with a problem of this magnitude. Now, back to Mr. Alok Vagrecha, who has told me that I shouldn't address him as senior, but I still don't mind to do so. I like the distinction, but anyways, Mr. Alok, please go on with his speech.
So I was speaking about this entire problem of pendency of cases. Now, you see, I was listening to Mr. Guha also about technological aspect and statistical analysis. See, these are things, I'm not a very technically sound person, but you must understand that law operates totally in a totally different way on ground. You speak about arbitration, but what about that poor person who is there in the tehsil level or at a district level? What about his case? He doesn't have money to pay to the lawyer. And now on top of that, you have a judge who has come, who is the byproduct of this rotten system, who doesn't understand the letter of law. He has come to occupy that seat because of some our system. He is much more bothered about his job, because if he acquits a person, there will be an explanation he is required to give to the High Court. So in order to avoid giving that explanation, the easiest way is out is deny him bail, let him go to the High Court to seek bail, let him go to the High Court to seek acquittal. That poor man languishes in jail for 10 years as an under trial prisoner, or for 5 years, or for 6 years, because the judge doesn't have the guts to acquit him or to give him bail. He, knowing fully well that this man deserves to be enlarged on bail. Now, when this appeal or this bail goes to the High Court, it occupies the docket of the High Court. Now, the High Court judge, who has a security of tenure, who cannot be removed from his service, except by way of impeachment, he listens to that bail, he takes another 15 days or 20 days or 1 month or whatever it is. And if it is a bail, or it's a appeal, he'll first hear 389. He'll allow or he'll dismiss. If he allows, then also that the appeal is going to occupy the docket of the High Court for another 10, 20 years. Here is the problem. Problem is the man who is manning the system. Unless you build that character in the persons who are manning that system, you cannot do anything. What is the need of keeping the appeal pending for another 20 years when you are suspending sentence? Suspension of sentence itself means either there is a prima facie case which is arguable. So why don't you hear that case at the time of hearing on 389 application itself? Either way, you are discussing the evidence at that time. There is no fun in keeping the appeal pending for another 20 years. But you don't do that. Secondly, coming to the adjournment, that many panelists have said that number of adjournments should be curtailed. It should never be done. It should never be done because there are so many situations which may crop up during the course of criminal trial or a civil trial. Sometimes the lawyer is not well. Suppose the lawyer is not well, are you not going to give adjournment? Are you going to pressurize the junior of the lawyer that no, you cross-examine the witness? Now that junior will cross-examine the witness, he will ask a question which he is not supposed to ask. That poor man might be convicted only on the strength of that question itself. When there is a convenience of the judge, he will give adjournment. When there is he is not convenience, he will not give adjournment. There cannot be law like this. Only because adjournments are given, therefore, you say that cases don't remain pending because of the adjournment. On ground, see, you don't have a fixed system of law of bails. Who will get bail, who will not give bail, till date you have not been able to lay down the proper guidelines. Why don't you enact a law that let there be a bail for everyone? Let there be a system that once I am talking about criminal cases. Once the police charge sheet is filed before the court, then in one shot you record the examination in chief of all the witnesses which the prosecution wishes to examine, so that the question of tampering with the evidence goes once and for all. It is foreclosed. Instead of modifying your system, we are trying to tickle the system that do this, do that. This is not the correct way of dealing with the problem. Secondly, there is no filtration level neither at the judicial level nor at the legal legal level. I mean, at the level of the, once a lawyer passes the exam, there is no mechanism of checking his performance. I mean, this is the only country, I think, in India, lawyers are not allowed to advertise. So a poor man, he sees the lawyer's office, he says he's a lawyer, without knowing whether he's a civil lawyer or he's a criminal lawyer, he's a service law specialist or he's a arbitration specialist, he goes into that office. Why don't you allow lawyers to advertise? So that people, a patient who is having pain in his stomach doesn't go to a neurosurgeon. Then why are you making the poor person or a litigant go to a lawyer without knowing about his qualifications and credentials? Only because you have a system that lawyers cannot advertise. We are living in an age of technology, and still we have laws which don't have any relevance. There are so many factors which contribute to the pendency of cases. Appellate court, trial court, you cannot. In the trial court, you cannot prevent cases from coming. A murder will take place in society, case is bound to come to session court. A rape will take, it will bound to come to the session court. But what you can regularize is that number of appeals. If there is a sound decision at the trial court level itself, then you can reduce the number of appeals, which you are not doing because the entire higher judiciary is functioning in a very feudal attitude. They presume that trial court judges are not honest. That is why trial court judges are mechanically convicting people, mechanically rejecting bails. So there has to be some character building exercise also in the institution itself. And I hope I've said whatever I need to say.
Right. Yes. Okay. But also, there is a point made in the first panel today, and since you've been talking about, the prisoners and everyone, there were cases that were pointed out wherein the prisoners themselves did not want to go out of jail, and that is something one can't blame on the judges. Like, this is a point.
No,
What do you have to? Yeah. What do you have to say?
The problem when there is a prolonged incarnation in the prison, is a very interesting thing. What happens is after a while, nobody from the family of the prisoner is interested in him. They stop visiting. They just stop visiting. This prisoner feels as if he's cut off from this entire world. A man who is sent, suppose a man, let's say 50 years or 65-year-old man goes to prison when he's, say, 55. He remains in prison for, say, 10 years, 65 years. Nobody is visiting him since last 7 years. He has made friendship in prison. Obviously, his world is there. He won't go out because at 65, his livelihood is gone. There is nobody visiting him. It happens. You see, it happens. These are practical realities. Yes, people don't want to go out of prison because they feel as if it is their home. I have encountered cases where people have come out of the prison and then they commit some minor offense and they again go back in prison.
No, absolutely. And this is something that has been highlighted. I'm going to mute you, sir, now. This is something that has been highlighted by all the panelists throughout. And Mr. I think Shivakant is also here. He's a former judge of the Calcutta High Court. We might take a comment from him as well. But let's just go to our key speaker for the day, Mr. S.K. Singhi. I've already told you he's the managing partner of S.K. Singhi & Co. And I see a number of counters that are there, both in chat also, and people wanted to ask questions. So we'll take more questions from the audience. And obviously, Mr. Shovik, you can switch your video on and counter once this key speech is over. Mr. Singhi, please have the dais.
Good afternoon, everyone. It's really a pleasure to address and be a part of this great seminar. Great in the sense that the topic is such a hot topic. Now, every day, the people who visit to the coffee shop and look for and had a discussion One of this discussion is a talk of the town regarding the pendency of cases and how to solve it, whether at all the people who are the street people or the people who are in the coffee shop or the people who do not have this kind of access will ever get to justice or not. As I have been speaking to the previous speakers and also sometimes in the morning also part of the seminar, everyone has this kind of concern, including the honorable judge who has been a part of our High Court in Calcutta as well. Just to counter a few what they have said before I start presenting my paper. As Mr. Vagrecha had said, he has rightly said, justice hurried is justice buried. No doubt about that. But imagine a fact, when the justice is delayed, is justice denied. As recently as 3 weeks back or 2 weeks back, we all must have read in newspaper. In Bihar, recently, 2 judgments were decided after a lapse of 101 years. And the crime was a petty theft of 25 rupees. And the gentleman was suffering this aguna for 101 years. And in the other one, the same thing, it was really 98 years or something that these 2 judgments were delivered. Is it a justice hurried or is it a justice denied? While we say that justice delayed, we don't say that justice should be, when we say that justice should be delivered, it should not be delayed. We don't mean that justice should be hurried and injustice should be done. But there has to be some reasonableness in delivering the justice. So the person who gets the justice also seems to have got the justice. Just on paper, an order is passed is not a justice actually. We have also recently, in 3-4 days back, I'm sure all of you must have read, a lady prisoner from the Indian prison, a Pakistani national, was released and she visited her home after 75 years. She had been languishing in the Indian jail when she was only a child of say 5 years or 10 years old. And after 75 years, she has been released and visited her home, where everything has changed. Not only his family members, but entire the mohalla, the entire loop, the building, nobody could have even imagined. Is it a justice? It is not a justice denied. When we are talking about the justice delayed is justice denied, we are talking about this kind of delay. Which are the delays? These are some of the examples. There are hundreds and innumerable examples in our country where justice has been delayed and it has lost its relevance even after 101 years. When you deliver this justice, that justice has no meaning. In fact, we are handling, in my law firm, we are handling some couple of matters which are prior to my birth. These are the title suits which are prior to the date of my birth. Can you imagine what will happen when the judgment is declared and the stage of those matters? I will not able to name the matters of this, but the stage of the matters is at present, they have not even completed the pleadings because the system our is such that one person or the other expires, and as per our rule, the other legal heirs have to become the party. By the time all the legal heirs become the party, someone else expires or some new phenomena comes in, and the process is going on. Even the trial has not started as yet. This is way, more than 58 years or 60 years. So where is the justice? Who will see the title? Who will see the end of that one? That is at the trial court stage. And when the trial ends, then he has the right to go to first appeal. He has the right to go to High Court. He has the right to go to Supreme Court. Just imagine the volume of years that will take. And who will see whether 7th generation or 10th generation, which generation will see that result? That is called the justice denied. And that is what we all are concerned about, how to avoid these kind of delays where the justice can be delivered and the people really get that, yes, something has been delivered to us. I have heard Mr. Aniban Ray, who is a part of our Calcutta High Court, since I am also from Calcutta High Court. I agree with him that the number of judges should be increased. At the same time, Mr. Bhagrecha had said that the specialized presiding officer should be there. Both are right at their stand. But in my opinion, the foremost and most important thing is the radical reform in the systems of working of the courts and the judiciary and all stakeholders. When we talk about the systems, we talk about the procedure, we talk about the limitation on adjournments or no limitation on adjournments. We talk about the dates, we talk about timelines. These are all a part of the reforms, and the government, judiciary, stakeholders, all are taking their respective steps at one point or the other to improve upon the system. But after a couple of years, when we analyze, we understand that the system has failed. Take an example of the reforms in terms of the recovery of the money dues to the banks. The initially government had started this DRT Act with an intention that money will be recovered fast. It's a specialized tribunal. After some years, it was realized and it was evaluated that the mechanism has failed. So we came out with the SurfaceI Act. Now, after some years, we understand SurfaceI Act itself is not sufficient and the process has failed. So we came out with IBC. Now, IBC, when it came in, it mandated that the entire matter, the process has to be completed within 6 months, 9 months at best. And look at the situation where we are today. The cases which are, when the NCLT or the IBC process start, the cases which were filed, even today, after more than 3 years or 3.5 years, are languishing in courts. No decisions have come. So even after you have set for the timelines and the judgments are not coming on, or it is getting held up in one forum or the other. And in IBC, the most important fact is that the right of appeal straightway from NCLT to NCLT goes to Supreme Court. Even the high courts have been barred to interfere in any kind of this proceeding. Even then, some of our high courts have duly interfered in SurfaceI matters, in NCLT matters. Even then, the matters are pending in Supreme Court, and we are still at the same stage. Of course, the recovery might have been a little bit extra, but then the manner in which the recovery should have been done is not done. That is what we call a decision denied. So when we talk about the reforms to remove the pendency of the cases, in my opinion, we should not only talk about the reforms in law and the procedure, we should talk about the reforms in the radical reforms in the attitude and willingness of all the stakeholders to reduce the pendency of cases. Whether there can be a law for that, there can't be a law for that. You can't control my willingness, or I can't control your willingness. The willingness has to come out of the characteristics, out of the training, out of the proper culture. For that, we need to take more appropriate steps. I tell you one example, which is a live example, which one of my seniors used to tell me on the part of willingness. One arbitration matter was initiated by a government department. And the gentleman who was the senior advocate, who himself is a brand in arbitration, was appointed on behalf of the government department. And he was fighting on the case. The arbitration started. After, say, 1 year's of time, the officer concerned, who was the handling officer in the department, he calls him and asks him, sir, ये matter और कितना दिन चलेगा? तो उन्होंने कहा, मेरे हिसाब से 6 महीना साल भर और चलेगा. सर, आप कितना महीना चला सकते हो? Then he got really shocked and he said, what do you want? You tell me. बोला, सर, मेरी अभी तक इस पोजीशन पे मेरी अभी 9 महीने या 8 महीने की नौकरी और बची है. इसका जजमेंट मेरे पीरियड में नहीं आना चाहिए, क्योंकि हमको मालूम है हम हारेंगे. अगर ये जजमेंट मेरे फेवर में आ गया, तो मेरे अगेंस्ट में चला गया, तो मेरी मतलब की फाइल खराब हो जाएगी, हो सकता है हमको पेंशन नहीं मिलेगी. तो उन्होंने कहा, चलो ठीक है, लेकिन इसका तो कॉस्ट है, बिना कॉस्ट के तो होगा नहीं. बोला, सर, कॉस्ट की आप चिंता मत कीजिए. Look at the phenomena where the government has the panel where they decide on the fees of the matter, and here the gentleman is talking about unlimited fees, but it should not be concluded within this kind of period. And it was agreed, okay, we will continue for 9 months. After 2 years and 2.5 years, the next officer, same thing, same question, and same time, मेरा सर 13 महीना का period है, ये judgment नहीं आना चाहिए. And this process continued for more than 7 years. And in the process, the advocate, how many questions you asked to the cross-witness? 5,000 plus questions were asked to the witness. This is the willingness has to come from all the stakeholders, not only from the party, it also from the advocate. If these kind of matters are there and if these kind of attitudes are there, where do we see the pendency to be reduced? I don't think we can ever have the pendency reduced. So when we are putting on the states on the reforms and the laws and the regulations, we should also look into how we inculcate the habit amongst the stakeholders to willingness either not to go to the litigation at all. So the pre-litigation advice, that should be very important. It doesn't come nowadays. Most of the lawyers or most of the people who come with a mandate to file a case, they come with a mandate only to file the case. They are not interested in what will be the outcome of the case. In my opinion, what we should do is, we should have the habit of preparing a case portfolio before initiating a certain case, irrespective of whether it is a small or big case, where the parties must get a pre-litigation advice, whether going to litigation is an option or there are other options available. If options are available, what is the outcome, what is the cost, what is the likely time hold? And once he analyzes and reserves this, then only the litigation should be started. That may go in a long way in educating the parties and taking a conscious decision either to reduce the litigation or the pendency of the cases, and also of the burden of the other people, and the justice can be delivered and made accessible to the people at the downstairs.
I've been listening to what you've been saying, especially your note on the fast track courts. Now, here's a statement, and maybe Mr. Shivakant and other panelists also, if Mr. Alok and Mr. Anirban are still here, they can also reflect on this, and we'll let you complete the paper after that. But question is firstly directed to you only, that fast track courts have reduced courts to a court of law and not a court of justice. Do you agree with this? As a lawyer, as a managing partner, do you believe that this has become the reality?
Well, as a lawyer or as a managing partner, I don't want to comment anything. But as a common man, I would certainly agree partly, I disagree partly. The fast track court's purpose, which was there and for which the fast courts came into picture, that has not been fulfilled. It has only remained as a fast track court, but the justice delivery system for which the object of the fast track court, that has not been forthcoming, that is not seen. So in my opinion, there needs to be a lot more to be done before the fast track courts really become the fast track courts.
Right, sir. But what exactly is it? Like, do you talk about the speed in which the system, the judgments are being delivered, or the quality of judgments that have come about? Because fast track courts have been accused of bypassing the law at times, especially while delivering judgments on serious issues.
Well, there are 2-3 factors which contribute to it. The one factor, of course, is the quality of the stakeholders, including the magistrate, the judges, and the lawyers, etc. The other party is the other important factor is the willingness and of the stakeholders. That is the party who is instituting the issues. Here, in this case, most of the time, it is either a government department or an investigating agency or a police authority or something. And because of the lack of proper training and the proper application of law, most of the time, the process and the systems get influenced. When I talk about process and system get influenced, means the delay occurs. If a government advocate is seeking time, it is easy to come. Even 300 days or 3,000 days delay is condoned by courts in 1 second without imposing penalty. Right. When it comes to the private respondent, even for 30 days delay, the court thinks 100 times before giving the condonation and imposes huge penalty. So these kind of things which needs to be streamlined, there should be a process, there should be a equality for both the sides. Right, it is not that just because the government is coming, so they have a right. Whenever they come, they can just jump into the court and take a time. The court normally, as a common man, what we see, the courts have just given a fire to the advocate of the opposite party, which is the government, and ultimately, at the end of the day, the delays of 3,000 days or 300 days is also condoned. Right. That these kind of things should stay. In my opinion, the system needs to be improved. The processes and training needs to be improved before we see the results actually.
Now, and we have Mr. Shivakant also, and we'll again then go back to Mr. Singhi. Singhi sir has also been speaking for a while. Mr. Shivakant also wanted to address this, and this question is open to you also, sir, if you can hear us. Do you believe, and who personally do you feel is also responsible for it? The fast track courts being reduced to mere courts of law and not courts of justice. Sir, I'll have to unmute you just a second. Yeah. Singhi sir, I'm putting you on mute and then we'll go back to you. All right.
Sure.
Sir, you'll have to unmute. You're not audible. You have to unmute. Yeah, yes, sir. Yes.
What I was talking about is that Mr. Singhi has rightly said that the court is very liberal insofar as the continuation of delay. when sought for on behalf of the estate. That is true. And the private parties are imposed with the cost. That is there. The Honorable Supreme Court has also decided in one case to go very liberally in condoning the delay. And that you might have gone through that judgment. I don't want to quote it. So that's the guidelines. That's why the court always think of.
No, but this point that was being discussed.
But actually, why this decision was, that is a background also given by the Honorable Supreme Court.
Right.
That why this the court should be liberal insofar as the condonation of delay is concerned, as regards the stakeholder is concerned, because of the red tapeism you can understand very well. So they are all tossing the files. Even the public prosecutor and the state lawyer, they are not getting their dues. The work done for them, they are not getting properly in time. That is also pending before the legal remembrance department, and very difficult. And that's why many of the good lawyers also left the panel. Mr. Singhi might be aware of and might have this impression about.
Yes, sir, you are
that is there.
That's exactly.
So far the fast track court is concerned, it is you can say it is a misnomer nowadays. That's it should be regularized, and I was advocating for it when I was in the High Court, to regularize all the fast track courts as a regular additional district judge. Why this would work? Honorable Supreme Court said that the fast track court judges, they are additional district session judges. Judges, they are officiating ad hoc, but they will remain in the cadre of subordinate judge. They can be a step down. What was the purpose? The purpose was to promote, not to promote, to give on ad hoc promotion to the subordinate judges, and to clear some backlogs in the sessions travel offences. That was meant for that. But now the fast track court judges, they have become a regular court like. Revision is also pending there, appeal is also pending there, appeal from Munsif judgment and all that. Matrimonial suit is also pending there. They are not supposed to. If somebody, then he is the fast track court judge, he is the subordinate judge rank. Then you claim that he has got the power embedded with to convict a person and impose punishment, even capital punishment, say, in 302, in deserving cases. How funny things, you know. So fast track court is misnomer in my view. They should be regularized because they are functioning at the same level, in the same breath as the regular courts are doing.
Right.
And perks and facilities are the same.
Right.
So they are demoralized to the extent that they belong to subordinate rank, still while officiating as additional district session judge.
Yes. The dog in the background is also extending support to the point you're making.
That is one of the incentive, you know.
Yeah.
Your mind is clean to that. You get the incentive from the government.
Absolutely.
Or the administration. I have advocated to the administration also. Full court has not accepted, but this was discussed in the full court meeting also of the High Court. And maybe that in the near future they will be regularized. Fast track court, so far as has been advocated right now by the Law Ministry, is for the POXO courts. Every 100 cases must have one POXO court, a special court. A special court that will be on fast track court. Fast track. So where is the fast track? Infrastructure is not provided. Actually, basic thing which actually require is infrastructure to the court, which is required to be provided. In West Bengal, so many courts are already standing, you know. They are under construction. Inner construction has not been done. Decoration has not been made. But the building is standing there for long. They are waiting some fund to get it finished and to house the courts. The courts in India, to my understanding, is not functioning well only because of the infrastructure. Infrastructure includes the staffing as well. Our staff are not well placed also. Sometimes in the High Court itself, they used to come by 11, going by 4:30 like that. How do you expect the work from the person? Only in the bench, the staff who are working, they are interested. They are working there. The litigants make them work, not the court. That's the thing. If you are upright, you can correct the situation. But that situation is not being done.
Yes.
Why the records are not placed? And direction has been given to place all the listed matters. They are not placed. Why? There are some in between.
I think Mr. Santosh has a question for you.
I don't want to explain that.
Yeah.
That's there.
Can we take the question, sir, with your permission? He has a question. Yeah. Please go on.
I will say that first, Singhi sir has not completed his argument, whatever he was delivering. I would like Honorable Judge Shivakant sir to clarify about the impact of digital illiteracy in judiciary. How is it affecting the process of delivering justice? And
no, it is working. Digital what is called literacy is already there. Even our staff, they are well equipped. They are well in the knowledge. And you will find in the original site, Calcutta High Court, they work very fast. They are very up to date. Even say, for example, somebody wants the last order to be placed, so that it is not in the record. They will get it printed from the desk itself in the courtroom. So they are so fast. And some of the original site rules are really very good. Because in the suit, because I was also in the suit court, and I have got this experience that the records, whatever the documents are, discovery and inspection of the documents, the lawyer, it is exchanged to them, and they will admit that they have to said that what are documents to be admitted, or what are documents to be on evidence to be proved. So it actually, it's a speed which is given to the court. This is not there in the lower judiciary.
Right.
Then again, you have got the judgment writer or the deposition writer. Dictation is given, interpretation is made, and they are taking down. Court is only to monitor and see that where the questions are required to be restricted or not to be.
Right, sir.
But in the judicial service, you will find we have the question is put on the doc, and we used to write. We used to translate the Bengali version into English and write. So it used to take time. And even today, you will find that the competent staff, so far as stenography is not there. So many of the judges, they are on computer, they are on their own, they are writing sometimes. Now, artificial intelligence is there. I can just switch on, and then whatever I am speaking, that is being read, and it is written down. But not all. Like you are giving the name of a person, you have to train that. A place or name of a place or a person or a thing, you have to train them, and that it takes time. So that intelligence, artificial intelligence is not also to that assistance, but that is.
Oh. Sir, you are muted by mistake. You were saying something. Please unmute. Yeah. Please go on. Sorry.
Actually, in sum total, what I understand is that you can say that the judges' holidays vacation should be reduced. That we have done. It's not so that we have worked during vacation also. The judges are there working. Right from the munsifi or the magistracy, they are always on duty. Every day they are on duty. It is not so that they are merely they are making fun out of their own life. It's not so. So they are working throughout.
Absolutely, absolutely.
Then they are accounted for. They have to send their disposal to the High Court. Even the High Court disposal is also noted down and it is sent to the Honorable Supreme Court. So that is the data collection, and that is the accounting. Sometimes our staff is failing in not sending or not noting down the disposed of cases. That is there. In the subordinate court also, when the suit is decided and disposed of, result has to be given in the appeal register. If it is appeal register, or in the suit register. That is not given there. Suit is dismissed for default. That has to survive for a month. Otherwise, the record is to be torn. You are not supposed to get it revived. So it is dismissed for default. You have a right to renew your prayer. You can file your fresh suit on that count, but you have to explain that the suit was dismissed for default. Default means no judgment has been passed, and the expertise judgment, when it is passed, it is judgment in absentia. It is no judgment. That is the jurisprudential theory. Every lawyer will know. So
no points.
The judges.
Well,
that's why what I say, that the trial court or the judges, they should avoid passing expertise order, because you must know that you are getting the expertise order. It is about to be set aside. Another party will come and get it revived. If I dismissal is also be avoided, because dismiss for default, sometimes the lawyers group, or the party, they want that should be dismissed for default. I have the experience as a lawyer also. My solicitor actually asked me to just watch the case when I was petty junior. I saved that case. Understood? When I said that I got it adjourned, I was asking for the passover, and thereafter said that no, all right, adjourned. Why you appeared? I was asked why you did appear. I had given you the instruction to appear. No. So why? Because the party is not coming, attending. So let it be dismissed, and thereafter I will give notice and he will come. Then we will revive it. So this is also one of the cause for the delay. We are all responsible. No one is spared. We are all responsible for the delay.
Absolutely, absolutely.
And delay pendency starts from the date the case is initiated. The delay is at the hand of the court. Does not mean only the judge. It is not the presiding judge. It is the members of the bar and the litigants who are behind him.
Absolutely.
Because they are overall, they are acting at the instruction of their client. That's why I say that the litigant is also responsible for the delay cause.
Right, sir.
Then adjournments, why you are asking for the adjournments? And the court has to give the adjournment. I can hear your 10 cases. That's why I used to simply display in my list. The 1 to 10 cases will be getting the priority after mentioning. And if no one is appearing in a second term, second call, third call, it will be dismissed. You have to appear. Otherwise, don't get your case registered or listed within 10. If any two parties who are interested in getting their matter done, you get them listed. 1 to 10 I will hear, surely. Other matters may be adjourned. Because it's not humanly possible that you will go on disposing of deciding 100 cases. Deciding 100 cases is not possible in a day. It's not with merit. It is a disposal. I used to dismiss 150 every day. 150, 200 in 2015. I was assigned with the old writ matters. They were all infructuous. So I listed them. After giving warning, I simply called second call, third call, dismiss. All were disposed of. Around 5,000 cases were disposed of. So there are so many cases pending even today. Admiralty cases are pending. Insolvency cases are pending. They are not cared for. They are unnecessarily pending. So they are also causing trouble to the administration.
Absolutely.
And judicial administration, your executive administration. You are thinking that a lot of cases are pending. What cases are pending? Are they require any merit or decision? No. They require disposal. Only it is on the record in the data. It is coming there.
Yeah.
Police has registered a MV case, traffic violation cases, 1,000 cases. Okay, fine. They are giving you the notice. You have not deposited the money. Money deposited the SBI. You have not deposited. Challan is not there. Then after a certain period, the matter is sent to the court, magistrate court. Those are all pending because the party is not in the knowledge. That case has gone to notice was given, but he has not looked after where the case is, why he should go for petty cases there. Right. Then it is the duty of the magistrate to send them the notice. Someone, you come before the court. You plead guilty or not guilty, like that. Right. So those cases are also pending. Yeah. No, so sir, points were noted. We had set up a committee in the High Court as per the what is called the scheme, as per the direction by the Honorable Supreme Court, the methods to be involved, how you are to dispose of the cases. So committees were all formed, and directions were given to the magistrate that all petty cases should be washed unnecessarily. They should not be kept pending after this period. So there are a lot of clearance. Maybe that those cleared matters, they have not been reflected in the data throughout India. Who knows it? Right. So with your permission, I'll go back to Mr. Singhi and we'll let him complete because he prepared a paper and that was ongoing. And then we can come back to you with questions. You can have the last word. Thank you. Thank you for that. Okay. Thank you. Thank you. You can. You're not audible. You're not audible, sir. Yeah, you were saying something. I was saying that you please spare me now. Yeah, no, definitely, sir. Okay. Thank you so much for joining. It's been a pleasure throughout. And your knowledge and depth of the research speaks for itself. I don't. Honorable Supreme Court India, in the recent past, today also there is a news paper report that what are the 2-3 things are required. You fill up the gaps, place all the judicial officers in place, infrastructure you provide. That is not there. Per 100 POXO cases, 1 special judge. Right. Where is the infrastructure? You provide the infrastructure. Right. In some, when the fast track court were being created, the lawyers, bar association, they actually cooperated us. They spared 1 bar association room to establish 1 fast track court. It is like that. In witness said, actually fast track court was established. The room which is for the witnesses, court witnesses, that room was converted to for that. You see, this is a very sorry affair. So it is whose responsibility? It is the responsibility of the estate. Right. Right, sir. Right. No, we'll jump back to Mr. Singhi. So thank you so much, sir, for joining the second panel as well. It was a pleasure having you, and you've just, you've gone through all the layers. I have Supreme Court many judgments. If I read them, it will take time, and you will understand the reason behind the law. Right. No, think for maybe a tea or a cup of coffee. We can come over, and obviously because I want to make the outcome document, I love to listen to that. But let's just go back to Mr. Singhi sir. Stay there for a few minutes. Okay. Singhi sir will complete. Let him. Thank you very much. I'll just complete in 5 minutes. I will not take much of your time. No, sir. Please go ahead. Thank you. It would not be an exaggeration to say that the efficient courts are the backbone of the modern and efficient economy. A sound judiciary is the key to enforcing laws and creating trust in the economy, allowing economic exchange between complete strangers by deterring fraud and increasing the incentives for fair play. When the justice system breaks down, the consequences are disastrous. A slow judiciary with a large number of pending cases reduces trust in the economy and makes people fearful. There is a compelling argument that addressing pendency, delays and backlogs in the appellate and judicial arenas is the next frontier for improving ease of doing business in the country. India's poor ranking in enforcing contracts related directly to its judicial capacity.
A slow judiciary forces participants to adopt loss minimizing strategy, which are disastrous in long run for the economy. The most initiative result is for the cost structure of the entire country and the economy to go up. Judicial effectiveness varies considerably throughout the country, and this has allowed researchers to measure the impact of a slow judiciary on various outcomes. This paper is an attempt to comprehend and complement studies on the impact of judicial delays on the social, economic, and legal systems structures in our country. A weak judiciary has a negative effect on economic and social development, which leads to lower per capita income, higher poverty rates, lower private economic investments, poor public infrastructure, and higher crime rates and more industrial riots. The problem of pendency has become worse in the last decades as the average percentage of cases under the trial in the state high courts and lower courts increased from 82.8% to 84.81% in the previous decades. The present Indian government has been vocal about improving India's ease of doing business ranking. Perhaps that should motivate them to heed the recommendations in the various economic survey reports prepared by the government. The problem of rising pendency in the judicial system deserves more attention. India is the sixth largest economy in the world with a GDP of $2.66 trillion in 2020. Because of its large population, India has the lowest per capita GDP. Many of us have read from various newspaper reports that India will become one of the largest economy in 2030. The long-term growth perspective of the Indian economy remains positive due to its young population and corresponding low dependency ratio, healthy savings and investment rates, increasing globalization in India and integration into the global economy. 70% of GDP is driven by domestic private consumption. The country remains in the world's sixth largest consumer market. Apart from private consumption, India's GDP is also fueled by government spending, investments and exports. In 2020, pandemic has affected trade in India and was the world's 14th largest importer and the 21st largest exporter. It ranked 63rd on the ease of doing business and 68th on the global competitiveness report. With 500 million workers, the Indian labor force was the world's second largest as of 2019. India has one of the world's highest number of billionaires. India is the world's sixth largest manufacturer, representing 3% of the global manufacturing activity and employs over 57 million people. India is the world's largest manufacturer of generic drugs, and its pharmaceutical sector fulfills 50% of the global demand for vaccines. The Indian IT industry is a major IT exporter of IT services with $191 billion in revenue and employs over 4 million people. India ranks second globally in food and agriculture production. While agriculture exports were $35.09 billion, India's telecommunication industry is the world's second largest by the number of mobile phones, smartphones, and internet users. The Indian automobile industry is the world's fifth largest in production. India has the world's fourth largest natural resources, with the mining sector contributing to 11% in the GDP. The second largest steel producer and the third largest electricity producer. Its GDP could overtake that of US before 2050, turning into India into the strong economic worldwide. However, to maintain this high growth rate of national income and development, we need urgently to improve our judicial system. Economic cost per case in India. Cost of pendency of case could be as high as 1.5% GDP. If court decisions were quick and delay reduced, economic growth could receive a boost to the extent of 1 to 2% of the gross domestic product. Speeding up the process will also help poor. In financial year 2022, the gross national income at current prices in India was estimated at amount to over 230 trillion Indian rupees. Even if we consider cost of pendency of cases at as low as 1% of GDP, then also 2.3 trillion Indian rupees will be huge cost to our nation. Just imagine the number of hours wasted by the plaintiffs and defendants in visiting courts for pending cases. Direct monetary and indirect monetary costs like mental torture, loss of health will be huge. The poor feel let down by judicial system. They all attracted towards extremist ideologists and taking the law into their hands. The result is that the cost of policing and enforcing law and order has come up in recent years. Our late President Pranab Mukherjee said in 2009-10, the Union Ministry of Home Affairs has increased the allocation for policing and enforcing law and order tasks by 25% in the budget. The second side of this story is that poor contract enforcement is ensuring the investment decisions now have a risk premium that factors the judicial delays. As a result, the cost of borrowing capital goes up. Many investment that would have been viable becomes unviable due to these delays. The bank checks bouncing cases are mounting and piling up for years together, whereas the mandate was to have the cases completed within a specified period of time. This problem was also highlighted by the late President Mukherjee. If one joins these two dots, the conclusion is obvious. Judicial delays are not only alienating the poor citizens, but also ensuring the economic growth vital to lifting them out of poverty comes to a grinding halt. The vicious circle snares at our judicial delays. Role of judiciary. What is the role of judiciary in our Indian system? Justice delays, justice denied, as we have been discussing. This phrase implies that if the justice is not carried out right away in a timely way, then even if it is carried out later on, it is not really justice because this was a period when there was a lack of justice. A sense of confidence in the courts is essential to maintain a fabric of ordered liberty for a free people, and three things could destroy that confidence and not incalculable damage to society. That people come to believe that inefficiency and delay will drain even a just judgment of its value. The people who have long been exploited in the smaller transaction of a daily life come to believe that courts cannot vindicate their legal rights from the fraud and overreaching. That people come from belief the law in larger sense cannot fulfill its primary function to protect them and their families in their homes, at their work, and on the public streets. With 5 crores cases pending in various courts, as I have explained earlier in my part 1 of today's paper, an average time span of 15 years to get the dispute resolved throughout the court system. The judicial system can hardly be described as satisfactory in India. According to 2020 Niti Aayog, it would be an astonishing 324 years to clear all the backlogs of the cases which have been listed by the pendency of the cases which are there as on date. In the courts for more than 30 years were numbered as 65,695 in December 18. By January 19, it had risen more than 60% to 105,560. The huge backlog in these courts have been just subject of several reports, debates in parliament and state legislatures, in judicial conferences and the media. Late Chief Justice A.S. Anand had observed the consumers of justice want unpolluted, expeditious and inexpensive justice. In its absence, instead of taking recourse to law, many be tempted to take law into their own hands. This is what the judicial system must guard against so that people do not take recourse to extrajudicial methods to settle their own scores and seek redress of their grievances. Our Supreme Court has expressed its deep concern at excessive delay in disposal of cases in the country. In All India Judges Association case, the Supreme Court expressed its desire that number of judges be increased in a phased manner in 5 years to raise the judge population ratio to 50 per million in India. The Law Commission and Supreme Court through its judgment has examined the problem of understaffing of judiciary and recommended 50 judges per million of population instead of existing 10.5 million per population. The judge population ratio in India is the lowest in the world. Far worse is the fact that out of existing sanctioned strength of judges, 25 to 30% of the judges has 100 plus cases on the list every day, against the maximum of 20-25 cases which a judge can dispose of in a day. Just the other day in one Supreme Court, if I quote it, I had asked for an adjournment, for a passover or an adjournment. The next date given by the Supreme Court was 2 months later. That is the kind of pendency, that is the kind of the schedule of the court that doesn't permit even a small adjournment, and you have to wait for the next date for 2 months. Thus, the malady of adjournments in the courts is inherent in both the sides of the court, lawyers and judges. We must increase the judges' strength with immediate effect. In other countries, the number of judges per million populations are: in Australia, it is 41, Canada, it is 75, England is 51, USA 107, and India, it is just 10.5 judges per million population. Other regions are poor infrastructure in the courts and absence of computerized records, no fixed period for disposal. There is no time limit fixed either by any act or code within which the cases must be decided. Therefore, the judges, lawyers, and even the litigants take it for granted that there is no urgency to finish the case. The cases go on and are dragged for years together. Lawyers are known to take adjournments on frivolous grounds or other grounds. The reasons range from a death of a distant relative of a family or to a family celebration. The reasons range from death to a relative to celebration. With every adjournment, the process becomes costly and the courts aren't for the litigants, but the lawyers get paid for their in-time appearance. Often lawyers are busy in other courts. Lawyers have taken up more cases than they handle. Hence, adjournments are frequently sought. So much time is wasted on the arguments of the jurisdiction, causes of action, sufficiency of notice, amendments of plaint, and other procedural matters. Procedural law needs to be simplified because howsoever good the substantive law may be, it can be effective only if the procedural delays and rules are simple, effective, and expeditious. There are many provisions in the laws providing ample opportunity for delaying the disposal of cases. After initial judgment, the opportunity of filing appeals, the further causes delay. Where the final judgment is secured, execution is more than likely to be reluctant and unjustified. All these contributes to the delays. The economic implications are hard to understand and hard to be amiss. A growing pool of empirical studies suggest that the slow court system discourages the growth of new business. And as we all know, for a growing economy, the foreign investments, the investments from the other sectors needs to become. The all countries who wants to invest in India or in our country or in any other country, they want the execution to be proper and fast. For an example, if any foreign country or investment wants to come to India, the first thing what they look into is the arbitration and the judicial system and disposal. When it comes to the arbitration, the most of them prefer the foreign arbitration. The Indian arbitration is the least preferred. The reason being that the delay, there is no time limit within which the arbitration will come to an end. And if the arbitration comes to an end, when the execution and the finality will be attained. The involvement of judicial system at the stages of execution is a great cause of concern amongst the global investors in the country. So the investments which we expected or which we would have been expected is really not coming forth because of the delays and because of the systems not functioning properly in our country as far as the judiciary is concerned. Thank you very much. I think we all need to do more. Thank you very much.
Absolutely, no, sir. And okay, for those people who don't understand this format, what sir was exactly doing is presenting of a paper. It's very different from a normal speech that is coming in. A paper is researched, written down, and then that's presented. It's not the same as the other panelists, speaking randomly on the topic based on the views and insights that they have. That is also what made the speech different, and that is why it was a bit longer on that side. But sir, the points have been thoroughly, I think, presented, and you very well highlighted the point of the citizens also, which some of the panelists didn't take into account. And I'm glad that we have the third panel for that, because the third panel is going to be dynamic and we will be shifting into the debate structure format.
अभी रिसर्च हम सुन रहे थे, इनका जो एनालिसिस था, अभी तक के जितने भी एनालिसिस थे उसमें सबसे अच्छा एनालिसिस सिंघी सर का था.
थैंक यू वेरी मच.
और आपने डाटाबेस जो है एनालिसिस दिया है, ये जो जर्नल वे में जो बात हो रही थी उसको आपने स्पेशलाइज कर दिया मैटर को.
Right. Or it is good to see Hindi Vyakta speaking in English also. I didn't mind that. And he will be speaking in the third panel. Let's wait for the third panel. Thank you so much for joining. And I'm still trying to keep up my energy because I am also tired. But let's wait for panel 3. Thank you so much, Singhi sir. Thank you for all the panelists who joined and are there in the audience.
Thank you.
See you all in the third panel.
Okay.
Please go ahead.
Good evening, everyone. First of all, thank you very much for inviting me to speak on a topic about which I'm not very much expert on this issue because my area is different. But I got the invitation from Nissan to speak on this topic. So I will try to speak whatever I think that how this delayed injustice is affecting the economy and the social society at large. So you take the example of infrastructure projects. So suppose, according to this economic survey reports, 4 or 5 infrastructure projects cost around 52,000 crore rupees. So if it delays in the courts, so it will cost around 1.5% of the GDP. So basically, it is direct delaying in the justice is directly impacting the growth rate of the country.
Yes, please go on. Please go on.
So this is the so what I was trying to say is that justice delayed can have impact at different levels. So at one level, at a higher level, if you see the aggregate level or the macroeconomic level, so we find that this is a direct impact on economic growth. So we have to build a system where cases can be delivered at a speedy rate and in a manner that there is no hasty decision has been taken, so that it is not going to impact our investment climate, our economic growth, keeping all in this mind. But if you see the disaggregated level, so what we find that the nature of population or the kind demographic characteristics of population, if you see, so the most of the cases that I have just gone through the data, we found that most of the cases like these criminal cases are pending in the states like Bihar, UP, Odisha, West Bengal. So these are the states which are most populous states, and these are the states where the large number of demographic dividends are there, which basically the working age populations are there. So these are the states where there is a future potential of economic growth, but there are a large number of pendency of cases of criminal and civil dispute cases. So there should be some mechanism by strengthening the infrastructure facilities or improving the judges population ratio or digitalization of the courts and all, so that these kinds of cases can be the under trials can be taken at speedy rates and the criminal justice can be delivered, so that the states can grow faster. I just wanted to give one more example here, that recently I was reading a newspaper where there is an eminent economist who was talking about different models of economic growth in India. So they had taken 4 models of economic growth, and according to him, it says that like Bihar, UP, West Bengal are the states which are basically the lagging states, and though these states are basically working as a like obstacle to the growth process of the India's growth process, to how to deal with these states. So again, when I was today reading this about these data about this justice delivery system pendency of cases, so we find that most of the cases are from these states only. So I think this is very important issue for that we have to deal with this issue.
Your internet connection is sort of paused. I think there's some lag on your part.
Yeah, now
it's back now. The internet sort of like lagged a bit. You can just continue. You were talking about.
So I was just talking about that how this pendency of cases is also one of the regions of this the states is lagging in economic India's growth story.
Yeah.
So take the example of Bihar. So initially, if you see take the example, do a comparative study of Bihar before 2005 and after 2005, we see that law and order situation has improved in Bihar. But the level of law and order situation has not improved, that it has attracted investment in Bihar, or much has not changed, other than some infrastructural issues has changed in Bihar, but much has not changed. So there is a need to change, because if this situation has not changed in the states, so the economic situation will not improve. So for that, this judiciary is one of the important component also, because if some cases are lost or in the process of under trials or in the process of admission, so there should be a system where cases can be delivered at a date, and we should try for that. That's what I was just thinking.
Absolutely makes sense. Makes sense. Even I think the 2017-18 economic survey report also highlighted all these in terms of stallment and how the pendency of cases have affected the ease of doing business. Do you have anything more to say? Please go ahead.
Yes, I think if the system goes like this, what I think that if you see at village level, people, the level of literacy is already low compared to two things I wanted to say. One study says that when the economic growth takes place and level of urbanization takes place, the cases will also rise. At the same time, if you see when the level of literacy is low, then the cases of filing is low. Like suppose take the examples of men and women or senior citizen and working population. So the cases filed by senior citizens are low compared to the working age population, or cases filed by women are low compared to the male. So what I am trying to say is that if the literacy rate will improve, the cases will be filed by more. So the thing is that at this time, people are basically suppose you are living in a village, so the basic mind of the people in the village is that if you go to the court, it will take a longer period of time to get the justice. So they try to do the resolution by doing some alternate mechanism. So that mechanism is always not good. One thing. Second thing is that it also increases their economic cost. If they suppose one person who belongs to the BPL category, or they belong to the APL category, and if they go to the court, so there is a chances that it will, suppose if the under trials goes for 1 year, 2 years in a criminal court, or in a civil matter it goes more than 1 and 2 years. So there is a likely chance that that person will come from APL to BPL. Like similarly, you take the examples of medical, if there is no medical facilities. So if a person is just above the BPL or just above the APL, and due to this medical expenditure, they fall in the trap of BPL. Similar things can happen in this case also. So I was just what I am trying to say is that we have to strengthen the mechanism, basically the infrastructure mechanism.
Sir, I would like to interject here again. So you've talked about rural areas per se, and you've highlighted the problem well, how exactly it is problematic. You're also pointing out the concept of access to justice. I think Kanksshi gathered a lot of info on that and shared it with us as well. These rural people, how they have a credibility problem also in terms of what will happen. They have an economic issue also because litigation today has become costly, and all of that. What do you believe in economic terms only, if I were to stick to that, can be a solution to the problem that you're very well highlighting in terms of the rural areas? How can we increase the access to justice for them?
Like, see, suppose I just try to relate with how people saving in rural areas improved with this system of the justice system. So due to the digitalization process, what used to happen that those who are working from rural areas in urban areas, they try to send remittance to their friends and relatives to the village, to their families. So, but due to this digital system, now they send directly to the family members. So their saving rate has increased. Similarly, what I feel is that if the digital system improves in the court system, or at the same time, like the behavior change is also very important, and in the lower courts, the behavior of the the court staff or this I think judges is very important to give a kind of confidence in the people that if they go to the court, they will get the justice.
Right. The manner and behavior and the willingness, even Singhi sir talked about. Yes, sir, please go on. Do you have anything else to add?
Not much, I have to say, because these things, I was just thinking that.
No, absolutely. And I think
impact of this.
I think they've been very well highlighted, and more than that, like this is sort of a family panel for me. My dad and my uncle is there. You are also like more of a brother to me. But it's important the issues that you have highlighted in terms of even, you know, not only the economic survey. I think the World Bank also in 2015-16 talked about the problem with respect to insolvency of cases and even
Yes.
the commercial contracts and everything. And it's well highlighted, especially when you talk about rural areas and states like Bihar. The state level analysis is also pretty well brought about.
Just one thing I was wanted to add here
Yes,
is
sir,
that,
yes.
see, you take the example of Naxal problems in India, particularly in those who are Naxal affected areas.
Right.
What we see, there is a negative relation between Naxal violence and the justice system.
Yeah.
So what is happening is basically there is an alternative court for those tribal peoples. They have set up an alternative court. So same thing can happen if this court is not disturbed. Systematic court, which is established court, which are not going to give justice the proper time or in a way, then people will try to go to the alternative court or alternative system of justice,
Right.
and there is a chances that the people will fall in the trap.
Right. No, absolutely makes sense. And that is where the credibility and the willingness comes into picture, right? Where that is where the accessibility that we've been talking about in terms of, you know, being able to access the judiciary, not seeing them as a figure, you know, which is very inaccessible and placing them on a pedestal wherein you can't really come back from. You cannot have that mental image. If you have that, you can't approach them. That is the crux of the point. Thank you so much for your speech. If you have anything else to say, otherwise we'll move on to our next speaker, Mr. Santosh Upadhyay, also
Thank you.
My dad.
Thank you.
Yes, thank you, sir. Also my dad, because okay, I've been addressing everyone by their names, yeah. So, but it is okay because of the formal format of the discussion. If you can hear us, is everything okay? Should I ask you to unmute? I don't know. I think he's left the dice or something because his video was turned on. Okay, let's jump to our key speaker for the panel, Mr. Sanjay Upadhyay. And he is, just a second, I think I'm receiving a call. Just a minute, all right? I'll just... Yeah, okay, you are here. All right, we'll come to you at the end because you are our key speaker. We'll go back to Mr. Santosh Upadhyay. And
actually, thank you for calling me. Actually, my internet connectivity was poor.
No worries.
So the thing is that I want to...
You'll have to wait. I have not done your introduction, even though it's family. I'll have to do that. So he is the Secretary General of Havra Chamber of Commerce and Industry, and he's been running his own proprietorship with more than 25 years of experience. He's also the Joint General Secretary of Laghu Udyog Bharati, West Bengal, and Laghu Udyog Bharati is a pan-India established organization. It's a pleasure to have you on board, sir. Now you can go on. Also feel free to switch between Hindi and English. The language really shouldn't be a barrier. आप म्यूट पे हैं, आप अनम्यूट करिए खुद को. हाँ.
Thank you, Nishan, and good evening to everybody. Today we have a lot of discussions from early morning 10 a.m. and till now we are just going on of the one discussion after another, and it was a very long and very creative discussion, and I hope that it will be a very nice, it has been a very nice opportunity for us to make a research report and present it to the Union Law Ministry, and where some social cause,
we hope so,
social cause affecting this delay in justice can be taken up. Now there is a large body of discourse on judicial delays. No availability of scientific data hampers any meaningful discussion and analysis of pendency of cases. This was also pointed out. What I am saying is was also pointed out by Law Commission in 245th report. So we went about building a database of 5 million cases pending in the 21 high courts and 700 lower courts. The idea was to understand delays minutely. So now to identify and address the pain points where these delays are taking place, a challenge was the lack of standardization of data. Actually, everybody is talking about data nowadays.
Yeah.
So database has become a major shifting point. You have to be digitally well connected. You have to be digitally strong, learned people in court also, because due to the collegium system of judicial process, the people.
Sir, I'll stop you for a second since you're talking about the data. Do you believe that there is a manipulation of data, because a lot of our panelists
everywhere there is chance of manipulating the data, and no data is even the data taken from Bihar, West Bengal, all are not these data cannot be implemented to other states. Why? Because there has not been any standardization of data. And what I think is that being a people of chamber and commerce, I must stress on the how it is affecting the economy, where our earlier speaker have also addressed the issue, and former GM of Federal Bank, Mr. P.K. Mohapatra.
Yeah.
Yes, he have given us a data that 10 lakh crores of NPA is there, and that suit is pending. What happens if this 10 lakh crores comes to economy? If the case is resolved and this 10 lakh crore or whatever be the amount, it comes to the economy.
Right.
Okay.
Again an interjection, because I think Mr. Ajit had his hand up and he probably has a question. Yeah. So if you want, sir, please go ahead and ask your question.
So I just want to add that what the current speaker is saying about the data is that, yes, there is a problem in the data. So who is compiling the data? Like suppose you take the crime data. So there is a NCRB who is compiling all data, all kinds of crimes is compiled by NCRB. But in the case of pendency of data, like different high courts are collecting data, like the Patna High Court is collecting its own data, Allahabad High Court is collecting its own data. So that's why the problem is the uniformity in the data. The kinds of data they are collecting and all. So there should be a body which can collect all kinds of data. Like Supreme Court has had some system of collecting the data, but I think there is a need of an independent body which where all these data can be collected together, and then so that it can be analyzed for academic purposes also.
Okay. Now, right, Mr. Ajit rightly pointed out hello. So I'm audible?
Yeah, am I audible? Yeah, no, you are audible. I'll just take that point before you go on to proceed with this speech. That independent committee point, there has been a lot of talks about setting up an independent committee for these data and all of this. But how do you exactly ensure that the committee is independent? And what is not to say that the current judges and everyone else that is involved in collection of the data is not independent? Can there not be a political or power influence even in that independent committee that you wish to create?
Maybe.
Both of you can answer it one by one.
Yes, whatever you are saying is correct. But if you take the example of like we have an institution in India, there is an institution like called MOSPI. MOSPI is collecting data for India's GDP or some other indicators. Like we have an organization called National Sample Survey Organization. We have a system of Census of India. So these type of institutions are collecting data, but there is some political influence also. Even that these institutions are collecting data that is well respected. So in that manner, we should build a body where these types of data can also be collected. Judiciary data can also be collected so that it can better analyzed.
Absolutely. Yes, we can go back to Mr. Santosh.
Okay. The thing is that these things are happening. So when we are talking about NPA, 10 lakh crores, what does it mean? That it is a huge amount. It can be, the expenditure can be made on building economy, building bridges, building infrastructure, which is lacking lot in our country. Not only that, there is a great socio-economic effect. Even there are a lot of NGOs taking advantage of our judicial process. They are just I have got a data where rupees 50,000 crores are locked up in a stalled project. The projects which are just which are operating, that the work has been started by government or some private agencies by getting tender and the contract. The project has been installed by NGOs. So these things are, see how it is affecting the economy, this judicial process. So it's taking advantage out of that, and they are derailing the process. It is not only affecting this economy, ease of doing business is also being affected. Even we know that ease of doing business of India is increasing, and it is very much in comfortable zone nowadays. But still, we have to do a lot because one of our participants today very rightly pointed out, Mr. S.K. Singhi, that arbitration is even the MNC which are coming to India is looking for the arbitration clauses, and they are not relying on Indian arbitration process. They are making the clause, they are inserting the clause that are the arbitration clause. They are inserting the arbitration clause that is not of India specific, that is for foreign countries. Right. So we have to make a maximum amount of changes. We have to go really, we have to take it as a what you can say, revolution. Unless we take it as a revolution, we cannot blame on judiciary, we cannot blame on executive. That is the thing which is going on from number of years, and everybody is actually saving its own face, whether it's executive or judiciary. The flaw is everywhere. It's not even the you can say what lawyers are doing. Lawyers are they are overburdened with cases. They are overburdened with cases. They are very the quality of lawyer is very the quality of good lawyer is very minimized in our country. They are very less. So what happening? They are the good lawyers are overburdened, and after that, what is going on? That they are taking adjournment as they are not able to handle the cases. So they are taking adjournment for their clients. And this adjournment has also become a lot of even in movies, films, adjournment has become an issue. Tariq pe tariq, and we have heard all those things in many movies. Right. So these things are also going on. So what we have to make a holistic approach of everything. Unless we make a holistic approach, we discharge our responsibility. Even citizens are responsible for that. How you can say that if suppose 1 crore, 4.5 crore case is pending, out of that 2.25 crore are people, those who are innocent, 50% are innocent and 50% are real culprit, those who have committed the mistake or done something wrong. So what is happening? What is happening is that the person, those who have committed the mistakes, are taking adjournments, cases, taking benefit of the judicial process, delaying the case, and lawyers are helping them to delay this process. Today I have heard that one of our panelists was saying that one case was absolved after more than 100 years.
101 years.
So what is happening? That after 100 years, the case was next generation won the case. What was the use of that verdict? There was no use of that verdict.
Right.
So the thing is, we have to make ourselves responsible. Being a educated society, being a responsible society, we have to make ourselves responsible. And we have to, it is a continuous process. It cannot be done in a day. It will be a continuous process. It will be a evolving process.
Right.
Research will be made,
Bilkul.
and then only something can be done. Even today, some of our panelists have given some very good advice that that before proceeding to the court, we should have an assessment area where we have to decide that whether this case is good for going in court, or it can be decided outside the court. So first of all, there should be a system, and I really love this situation. If before going to court, many of the issues can be decided outside the ambit of the court, because maximum of the cases which are pending are even not eligible for going to court. See what is happening in case of EIL. People are taking advantage of filing public interest
misuse. Yeah,
misuse
of PIL.
Yeah, and just engaging court. So the thing, what is actually happening? Actually, the thing is happening that those who have got the money and power are very much they are getting justice. They are approaching judiciary. They are making whatever they want. They are harassing people. Those who don't have money. So the thing is that we have to think judicial reform should be done. Executive should think in direction without any hesitation. They should make a law, repeal the law, whatever it is. You should have to do, and you have to take corrective measures to benefit the society as a whole, because the thing is that it is affecting in economic terms. When we go, then we feel the real number could be as high as 1.5% to 2% of the GDP. Can you imagine? This is based on a survey of 300 lower courts, where they have interviewed around 9,000 litigants. And the state of judiciary also has an impact on India's record in the World Bank's ease of doing business ranking. Right. In the 2015 report, India is ranked 178 in the enforcing of contracts and 176 in the resolving of insolvency. So, enforcing of contracts, if you are so immature economy that you cannot enforce your contract. So out of 191, you were ranked in 2015. You were ranked 178. So what is the situation? You can understand. What is the situation?
I have a question for you. Just
it is improving.
Yeah. No, I get that, and you've been talking about a lot about stalling projects, and I think Mr. Ajit has also raised his hand. We'll also take a comment from him after this question. You talked about NGO stalling projects, right? And this is, I think, in reference to a report from the IB also in terms of nuclear and coal power stations back in 2014. But why do you feel that these NGOs would stall projects? Like anyone can take this question. Why would an NGO try to stall the project?
I think Ajit ji is in Delhi, and he's a good professor also, so he will be able to question this answer in the right direction.
Yeah. I'll also make a comment about it, but let's just go to Mr. Ajit first. Yeah, please go on, sir.
Okay, I will try to answer this question also, but I have 2-3 bold points that just I want to add what the speaker is saying. Yeah. The one thing is that we should also see, or we should also try to relate the pendency of cases and the condition of prison in India. Like due to this rising pendency of cases, what is happening there, the prisons are overcrowded in most of the states in India, and the condition of prisoners are very pathetic. Like their social and mental condition are very pathetic. So we should try to, so in that direction also, even either you better try to improve the infrastructure of the prison so that they can live in better life, because those who are basically not all these prisoners are are criminals, or they are proved to be criminals. Right. They are charged in some cases. So charge doesn't mean that they are guilty. So in that case, you should improve the infrastructure of the prison, or you should try to, the under trial process should be speedy so that they can get easily to get justice on a time. The second thing that what he was saying is that about this, how can cases can be resolved outside the court. So one thing I have an idea is that we should focus on to strengthen the local mechanism or the local institution. That in the first instance, there are some kind of cases that should not be arise. Like I gave example of two cases, kind of cases from Bihar. One is related to money laundering. So money laundering is a big business in Bihar. So lots of cases are related to money laundering. So if the state government take the proactive measures in preventing the money launderings, so the case will not arise. Similarly, the case is related to land disputes. There's a large number of cases in Bihar related to land disputes, and these cases are mostly civil in nature. They got converted into the criminal cases. So again, if you build a system, local administrative system or institutions properly, or the role of executive and administrative or this basically legislature is very important here, is that they should build, they should basically come with a kind of reforms measure where these kind of dispute does not arise. Like large number of land dispute cases are taking place in Bihar. So I think in that case, I was just trying to say that the local, basically strengthening of local institution is also very important, so that we can reduce the load.
Lok adalats and everything. Yeah,
Lok adalats are there. Lok adalats are there. But again, this strengthening is very important.
Yeah, no, absolutely.
As far as is concerned about the role of NGOs, what role NGOs are playing? I think the NGOs are playing both roles. They are playing good roles also. They are playing bad roles also. Good roles in the like you take the examples of there is a NGO run by Aruna Rai. So you cannot say that this NGO is doing this, basically trying to install something like RTI, Right to Education Act, or Right to RTI Act, all came through this long protest or long struggle by the NGO which is running by Naraiji. Similarly, there are a large number of good NGOs in the country which are helping in this process. But there are NGOs also for certain motives or certain states that can be interest by local groups, interest by political groups, or there is foreign influence also, where these NGOs can installing the projects. So we have to see both the roles.
Absolutely. And we'll come to you. Before that, I'll just address the point on NGOs, because that's a very interesting point, and even he's commented on that. I think this is in reference to the IB report in 2014. Why and which NGOs will stall the project? I have not really spoken as a panelist, but I'm just gonna make a 30-second statement here. So there are foreign funded NGOs that function, okay, and they promote a certain Western agenda, especially in affiliation with certain countries, and they were stalling projects related to nuclear and coal related plants, and that was really important in terms of not only the defense but also the economical structure of India, and that is what the IB told the central government, and that is wherein this stalling of the entire NGO came from. And in case of the viewers who are watching and want to know more about the hindrances that NGOs are facing and the counters, you can all go through the FCRA Amendment Act. There has been a lot of dispute around it. A lot of scholars have written on it. The Foreign Contribution Regulation Act, something along those lines, and that is specifically in relation to the NGOs. And now we'll go back to Mr. Santosh, and he'll make his concluding points. You have to unmute yourself. Yeah,
I will really conclude now at this stage, because what basically I want to say is that there should be suggestions coming from all the stakeholders of democracy, whether it is business, whether they are economists, whether they are banking sector, whether they are judges, lawyers, anyone from the ground level, from the people, those who are suffering from the cases. Then only we can combine the whole data, and then we can standardize it and put it into the effect, and that will really that will really solve the problem. Actually, it is we are in an emergency situation. Where we need a surgeon that just comes and operates. Unless that is, if it is not happening in the judiciary, the judicial support system will collapse. Actually, why I was saying that litigation advice suggested by today, suggested by one of our panelists, Sri S.K. Singhi, that pre-litigation advice is very important, and it can be done on the behalf of government, because if you go to lawyers, they in pre-litigation advice, they will just tell you advice. Maybe that there are some good lawyers also. I'm not telling, because I'm not thinking about those lawyers. But the thing is that there are some, the maximum of lawyers are there who will divert you to go and file the case. But there should be a pre-litigation advice on government government priority, and that how that is going to affect that there are many other processes alongside with judiciary. It is not important you to go and file the cases. If you can get the remedies under various infrastructures of government wings.
Yeah.
So the thing is that we have to see whether I think and I hope that if this pre-litigation advice is made to the clients who are not aware of actually the
what is going about
legal things, then it will be fruitful, and it will show a good result within year.
Right.
And
And
the things will
absolutely
improve.
And we congratulated Mr. Singhi about this also, and it's
Yes,
great that the announcement was made.
and certainly I
on this
also
panel.
suggest that this is going to be a very breakthrough, and
Right.
you should incorporate this in your research report, and which you are going to present in Union Law Ministry. And I will, if anybody has any
Conversations have been really riveting, and you want to take part and you want to talk and all of that, but at the end of the day, it's physically very challenging as well. So now we come to the key speaker for our third panel. He's a member DRUCC of Eastern Railway. He's the convener of the Landowners Committee, Havda Chamber of Commerce and Industry, and he shares 30 years of experience as a proprietor of Shri Namami Udyog and director SS Procon Limited. I hope you'll be addressing a speech in Hindi, sir, because we've had a lot of English speakers today. So that'll be really fun if we get to some hear some Hindi as well, and that'll be a change of taste also. Over to you, and I'll interrupt you in between and ask questions. So all the best. Please go on.
धन्यवाद सभी को। अभी जस्टिस तमन्ना बेंगलोर में एक जस्टिस के दिवंगत जस्टिस की शोक सभा में बोल रहे थे कि न्याय इसलिए नहीं हो पा रहा है कि क्योंकि भारतीय भाषाएं उसके साथ संलग्न नहीं है। तो भारतीय भाषाओं को न्याय के साथ जोड़ा जाएगा, तो जिसको न्याय की सबसे ज्यादा जरूरत है, जो न्याय ओरिएंटेड वर्क होना चाहिए, जिसकी जो वादी है वो उस न्याय को समझ सकता है, उसकी व्याख्या कर सकता है, अपनी बात को रख सकता है। और ये बात प्रधानमंत्री ने चीफ मिनिस्टर और हाई कोर्ट के जजों के एक सम्मेलन में भी 10 अप्रैल को इस बात को कहा था कि हमारी भारतीय भाषाओं में न्याय का होना बहुत जरूरी है। जो हमारी भारतीय भाषा स्थानीय भाषा है उसमें न्याय का होना बहुत जरूरी है। और जब हमारे अभी जो प्रेसिडेंट जो न्यायविद थे, अधिवक्ता थे, जब वो प्रेसिडेंट बने तो उनका फर्स्ट जो स्पीच था इसी पे था, फर्स्ट भाषण इसी पे था कि भारतीय भाषा में न्याय होना बहुत जरूरी है, क्योंकि न्याय जब तक दिखता नहीं है तब तक न्याय माना नहीं जाता है।
सर आपको पहला इंटरजेक्शन यहाँ पे इंटरजेक्ट करूंगा और ये ऐसे ही चलते रहेगा थ्रू आउट। मेरा सवाल
हमारा मुख्य विषय पे,
मेरा सवाल सुन लीजिए और फिर उसके बाद आप मुख्य विषय पे आगे बात कर सकते हैं। इस सवाल को आंसर भी करिएगा। आप ये जो बोल रहे हैं कि भारतीय भाषाओं को होना चाहिए, व्हाट एग्जैक्टली, लाइक हाउ डू यू डिफाइन दीज लैंग्वेजेस? क्या आप हिंदी के को रेफर कर रहे हैं? क्या आप संस्कृत को रेफर कर रहे हैं? क्या आप बंगाली को रेफर कर रहे हैं? क्या आप मलयालम को रेफर कर रहे हैं? बिकॉज देयर आर सो मेनी लैंग्वेज। तो आपको क्या लगता है किसको इंक्लूड करना चाहिए?
जैसे अभी सुप्रीम कोर्ट में प्रचलित 9 भाषाओं को जोड़ा गया है, उसमें न्याय को प्रिंट करके दिया जाएगा। और सुप्रीम कोर्ट का ये माने ये आदेश है कि जहाँ पे जिस तरह मद्रास हाई कोर्ट में तमिलनाडु जो तमिल भाषा है उसमें जो है किसी भी केस की व्याख्या हो, स्थानीय भाषा में लिखा हुआ हो। क्योंकि एक समस्या और भी थी कि जब मतलब अंग्रेज जो है आए भारत में, तो उस समय हमारे यहाँ फारसी में सारी न्याय की जो है भाषाएं लिखी जाती थी, तो लोग उस चीज को समझ नहीं पाते थे और उसमें कुछ भी लिख दिया जाता था, वो इंटरप्रिटेशन हो जाता था उसका। तो न्याय समझ में आना चाहिए कि हमारे पक्ष में क्या न्याय आ रहा है और कहाँ इसमें त्रुटि रह गई है। तो भारत जो राज्य की प्रचलित भाषाएं, हाई कोर्ट उसमें अपना कार्य करे, और जो सुप्रीम कोर्ट है वह जो है जो जिन भाषाओं को अभी लागू कर रहा है, जैसे 9 भाषाओं में अभी उन लोगों ने कहा है कि हम 9 भाषाओं में अपना जो है जजमेंट देंगे, तो उस प्रकार की बात अभी चल रही है। क्योंकि अब मुख्य विषय पे आना चाहता हूं कि आज का जो विषय है न्यायिक विलंब पर आधारित है। अच्छा, ये न्यायिक विलंब को अगर हम देखा जाए तो राष्ट्र की जो जिस प्रकार से इसका क्षति हो रही है राष्ट्र को, इसका हम सबसे छोटा इकाई परिवार को पकड़ते हैं। छोटा इकाई परिवार होता है। यदि परिवार में जो न्याय करने वाला मुखिया है वह पक्षपाती हो जाए, या वह जो है मतलब सही निर्णय न दे, या निर्णय में विलंब करे, तो क्या परिवार चल सकता है? ये संभव नहीं है। या भाई उसके बच्चे हैं तो खुद अपने बच्चों के लिए न्याय करे, दूसरों के लिए न्याय न करे, तो ऐसा परिवार चल नहीं सकता। राष्ट्र की सबसे छोटी इकाई परिवार है, तो उसी प्रकार राष्ट्र भी चलना मुश्किल हो जाएगा। क्योंकि आज जो एक रिपोर्ट आया पीआरएस लेजिस्लेटिव रिसर्च के का जो है 15 सितंबर 2021 का, उसमें उसने बताया कि 4.5 करोड़ मामले लंबित हैं अभी तक। और फिर अभी जो संसद में एक बयान आया जो है किरण रिजिजू का, 5 करोड़ मामले लंबित हैं। तो आप ये समझ सकते हैं कि ये जो विलंब हो रहा है न्याय में, इस न्याय के विलंब होने के चलते क्या होती है, अराजकता फैलता है। अराजकता फैलने का मतलब क्या होता है, तो जिसे अभी झा जी ने बताया कि वो जो बिहार में जो नक्सल ग्रुप और ये सब जो माओवादी सक्रिय हैं, उसमें सबसे बड़ा कारण क्या होता है, जब न्याय नहीं मिलता है तो व्यक्ति उसको बदले की भावना से कुछ भी करने के लिए आतुर रहता है। तो वो कभी नक्सलियों के साथ मिल जाता है, या किसी प्रकार से वो जो है मतलब किसी ऐसे असामाजिक तत्वों से मिल जाता है जो जिससे वो अपना बदला ले सके। तो इससे क्या होता है कि नागरिक भी इससे जो है प्रभावित होते हैं और समाज भी प्रभावित होता है। और जब नागरिक जो है अराजक हो जाएंगे तो समाज का विकास धीरे धीरे अवरुद्ध होने लगता है। आप देख लीजिए किसी भी जो है देश का, उसका विकास इसलिए अवरुद्ध हो गया कि वहां की अराजकता बढ़ गई। जैसे अभी एक रिपोर्ट आया जो है वर्ल्ड जस्टिस प्रोजेक्ट रूल ऑफ लॉ इंडेक्स 2021 में 139 देशों पे सर्वे हुआ था। तो 139 देशों के सर्वे में जो है पाकिस्तान का स्थान 130वें नंबर पे है। आप उसकी आर्थिक प्रगति देख सकते हैं क्या है। और भारत की स्थिति वहां पे है 79 पोजीशन। लेकिन नेपाल की स्थिति भारत से भी अच्छी है, 70वें नंबर स्थान पे है जो है। तो क्या होता है कि जब आप विकास करना चाहते हैं तो आपके पास शासन व्यवस्था दुरुस्त होनी चाहिए और आपकी न्याय व्यवस्था दुरुस्त होनी चाहिए। क्योंकि जो बाहर से भी लोग आएंगे उनको ये लगना चाहिए कि यहाँ हमारी बात सुनी जाएगी। अगर बात नहीं सुनी जाएगी तो न्याय हमको त्वरित मिलेगा। तो आज मैंने जिस प्रकार से और लोगों ने डाटा दिया कि भाई यूरोप में 10 लाख लोगों पे 210 न्यायाधीश हैं, अमेरिका में 150 170 न्यायाधीश हैं और भारत में अभी 20 न्यायाधीश हैं। तो यह स्थितियां बन रही हैं, अराजक बन रही हैं। और न्यायाधीशों, कुछ लोग सिविल सोसाइटी वाले कहते हैं भाई न्यायाधीश इतनी छुट्टी लेते हैं, तो सुप्रीम कोर्ट वाले 180 से 90 दिन काम करते हैं, हाई कोर्ट वाले 200 दिन काम करते हैं, तो जो लोअर कोर्ट वाले जो है 210 से 15 दिन काम करते हैं। इतनी छुट्टी में जो है छुट्टी में समय चला जाता है। लेकिन कुछ जो है जो न्यायाधीश हैं, जो चेतना प्रबुद्ध लोग हैं, वो आज भी जो है छुट्टियों में भी अपना काम करते हैं, ऐसी बात नहीं है। तो ऐसे लोगों को अपने को देखना है। लेकिन जो लंबित हमारे मामले पड़े हुए हैं हमारे देश में, वो जो है एक रिसर्च जो है बताया गया, जो है हरीश नरसप्पा, जो बेंगलुरु के में दक्ष के।
सर एक बार फिर आपको रोक रहा हूँ क्योंकि आपने अपना सेकंड पॉइंट बहुत डिटेल्ड वे में कंप्लीट कर लिया और बहुत ही डिफरेंट और एक यूनिक इंसाइट आप लेकर आए। मैं जितना समझ पाया हूँ, आप मुझे बताइए कि आप इसी डायरेक्शन में इस बात को रख रहे थे कि नहीं, कि अगर ये न्याय और पेंडेंसी ऑफ केसेस जो है वो बढ़ता है तो ये मिलिटेंसी और टेररिज्म प्रमोट करता है। इज दिस व्हाट यू आर सेइंग? ओके,
ये स्वाभाविक है,
बिल्कुल।
यह प्राकृतिक परंपरा है कि अगर मान लीजिए आपको न्याय नहीं मिला, आप क्रोध में है, क्रोध एक ऊर्जा है, यह गलत डायरेक्शन में भी जाती है, वो अच्छे डायरेक्शन में भी जाती है। अगर वह क्रोध बदले की भावना से गलत डायरेक्शन में चली जाती है तो समाज का विघटन होता है। तो इस प्रकार से कोई भी व्यक्ति जो जिसको न्याय नहीं मिलेगा, वह तो मान लीजिए, हम कहते हैं उदाहरण के तौर पे एक बात बताते हैं, आपको किसी जो है सबल आदमी ने किसी आपको मार दिया और आप जो है उसका कुछ समाधान नहीं निकाल पाए, तो आप क्या करेंगे? आप तो वही करेंगे ना भाई, जो है कि फिर उसको, अगर उसको गाली भी नहीं दे सकते तो मन के अंदर तो गाली आप देंगे ही जो है। तो यह तो प्राकृतिक स्थिति है, इसको जो है कि कोई इसको जो है वो मतलब वो नहीं कर सकता है। इसलिए जो प्राकृतिक स्थिति है, इसलिए मैं कहता हूं कि आप किसी भी कार्य में रहें। देखिए मनु ने कहा एक बात जो है कि यदि न प्रणयत राजा दंड दंडेशु अतीन्द्र शूले मत्स्यानि अपच्छन्य दुर्बलान बलवत्तरा। इसका भावार्थ है, यदि राजा दंडित किए जाने योग्य दुर्जनों के ऊपर दंड का प्रयोग नहीं करता है तो बलशाली व्यक्ति दुर्बल लोगों को वैसे ही पकाएंगे जैसे सूल अथवा सीख की मदद से मछली पकाई जाती है। यह मनु ने ही कहा है। तो दंड का विधान जो है हमेशा से रहा है। तो इसलिए क्या है कि जो न्यायालय है जो दंड का विधान करता है, वह अगर कमजोर पड़ने लगता है तो व्यथा दूसरी तरफ से निकलने लगती है और व्यक्ति फिर समाज में अपनी स्थिति को मजबूत करने के लिए वो कोई भी चीज का अवलंबन ले सकता है।
Absolutely, no, I understand। और आप काफी एक यूनिक इंसाइट लेकर आए, इसके डायरेक्शन पे भी हम जाएंगे। आपको 2 मिनट के लिए पॉज कर रहा हूँ। अर्ची उपाध्याय भी जुड़ चुकी हैं एंड आई थिंक वो तापनीस हैं और उनका कॉन्स्टेंटली एक प्रोग्राम चल रहा है और इसके बाद भी वो लीव कर देंगी, तो वो थोड़ी देर के लिए आए हैं। वो कुछ कहना चाहती हैं, वापस आएंगे क्योंकि आप ही की स्पीकर हैं। यू विल ऑब्वियसली ऑलवेज हैव द लास्ट वर्ड एंड वी विल आल्सो टेक क्वेश्चंस। अगर अजीत सर आपको कोई भी क्वेश्चंस हैं तो आप कमेंट्स हैं तो आप उसको रिजर्व रख सकते हैं। आप संजय जी के बोलने के बाद बोलिएगा। आर्ची, यू कैन प्लीज टेक द डायस।
Evening. As we all know, the organization of such events are generally the result of close cooperation among several institutions and individuals. It is my great pleasure to express on behalf of the organization and on my own behalf of a deep appreciation for the support and encouragement given by all of you, all of the speakers. I extend a really hearty vote of thanks to everyone present today in all our panels. I know it's been a long day, so thank you for being a constant support, for listening, for guiding us, to all the dignitaries who spared time from their busiest schedule to grace the occasion. Today, we had an opportunity to hear your insightful thoughts.
Some great insights. Thank you, Archie. You can mute yourself now. And if you want, you can leave also. I understand the urgency. We'll get back to you, Mr. Sanjay. Sorry for disrupting your flow. You're talking about how militancy and the sense of terrorism also comes along the way, in the sense that people start to rebel when they're not given the rightful justice that they deserve. And please go on. I am sure you have a lot to add. Please go on.
तो मैं विषय रख रहा था जो अराजकता के बारे में, कि न्याय विलंब से मिलने से या न्याय नहीं मिलने पे अराजकता हो जाती है और बड़ा मछली छोटे मछली को खा जाता है। ये मत्स्य न्याय बोला जाता है इसको, जो है 23/7/2022 कल के दिन जो है शनिवार को सीवी रमन्ना जो है रांची आए हुए थे। तो वहाँ जुडिशियल एकेडमी में नेशनल लॉ यूनिवर्सिटी में जो है वो एक व्याख्या आयोजित थी, तो उसमें उन्होंने व्याख्या दिया। तो अब एक देखिए विषय ये है कि एक CGI जो है चीफ जस्टिस ऑफ इंडिया बोल रहा है कि हम लोग तो समाज से ही आते हैं और फिर समाज में हमको जाना रहता है, और समाज में हम लोग जाते हैं तो हमारे सुरक्षा की कोई गारंटी नहीं है। देखिए अब उसकी सुरक्षा की कोई गारंटी नहीं है। देखिए धनबाद में भी एक ऐसी घटना हुई थी कि जज का एक्सीडेंट हुआ था, उसकी मृत्यु हो गई थी, उसमें CBI भाई बैठे थे। लेकिन अभी हाई कोर्ट, कर्नाटक हाई कोर्ट में जो है एक हिजाब विवाद पे भी जजों को थ्रेटिंग आई, जो है बनारस में भी ऐसा थ्रेटिंग आया। तो अराजकता, मैं कहता हूं कि अराजकता, जब न्याय व्यवस्था दुरुस्त नहीं रहती है तो कार्यपालिका भी दुरुस्त नहीं रहती है, क्योंकि जो अपराधी है वो जानता है कि न्याय तो बहुत विलंब से मिलेगा। अगर हम कोई अपराध करते हैं तो न्याय के लिए कोई दिक्कत नहीं है, खाली हमारा बेल हो जाए तो 20 साल 25 साल चलेगा। बाहर निकलने के बाद वो जो है गवाहों को प्रभावित करके और जो है बच जाने की स्थिति में रहता है। अक्सर बच भी जाते हैं, 50% केस में तो बच भी जाते हैं लोग। तो इस बात का भय जो है हमारे CGI को भी है कि हमारे जज जो समाज से आते हैं फिर समाज में जाते हैं, और वे उनकी सुरक्षा का दायित्व जितना एग्जीक्यूटिव के पास सुरक्षा का व्यवस्था रहता है उतना जो है हमारे न्यायाधीशों के पास नहीं रहता है। तो स्थिति माने जो चिंताजनक है, अराजकता की स्थिति है, वो CGI के माध्यम से भी प्रकाश में आ रहा है। तो इसके लिए जो है विलंब जो न्याय है, आप इसके कारण में जाएंगे मूल कारण में, तो जो विलंब से न्याय हो रहा है वो इसके कारण में यह भी एक आधार है।
Right, sir. I think it's perfect to stop you and take a pause here because आप एक बहुत ही different aspect लेके आ गए डिबेट में, जो कि बहुत ही अच्छा है. And I was waiting for someone to address it also because the CGI has also spoken about it, and I really commend you for that. आप ये बहुत ही अच्छा point उठाया है आपने, and it is well pointed out also in terms of we talk about political aspects, we talk about economical aspects, legal aspects, but this threat. That even the judicial people are supposed to be the protectors of law and their interpreters and all of that, when you talk about Supreme Court and all of that, yeah. But the sense that you're pointing out in terms of real life practical threats, और ये ऐसा नहीं है कि आप कोई आउट ऑफ द वे लाइन जाके कोई थियोरेटिकल बात उठा रहे हैं, ये प्रैक्टिकलिटी पे है, ये एग्जिस्ट करता है हमारे सोसाइटी में, एंड एक दीमक की तरह है जो कि नहीं होना चाहिए, एंड दैट इज अ पॉइंट वेरी वेल मेड. दिस वाज द मोस्ट इंटरैक्टिव पैनल आई फील, एंड जिस तरीके से संजय जी, संतोष जी ने अपनी बात रखी वो काफी रिमार्केबल था. इवन अजीत जी वाज वेरी टू द पॉइंट, एंड दैट इज इट फ्रॉम आवर साइड. We finally conclude the National Legal Summit 2022. Thank you to all the judges, Harvard alumni, officers, anyone and everyone who has joined. BB sir, he was there throughout in the panel one. Thank you so much for joining, and finally thanks to myself for hosting this. I'm also tired. Let's end this discussion now. Thank you so much.